For judgment item number 1, CRLA 22 of 2003.
The appeal is dismissed.
For judgment item number 1, CRLA 22 of 2012 and JCRLA 29 of 2012.
We've converted the offense to 326, confined it to the period of 10 years. So they'll both be released now. We've convicted them for the offense under section 326 IPC. Sentenced them to 10 years. So
For
they will be
judgment
released.
item number 1, CRLA 22 of 2012 and JCRLA 29 of 2012.
We've converted the offense to 326, confined it to the period of 10 years.
29
So they'll
of
both be
2000,
released.
my case is
We've convicted
29
them for
of
the offense under
2008
section
Act number
326.
applicable to.
Correct.
My
IPC.
lord,
Sentenced them to 10 years. So
For
they will be
judgment
released.
item number 1, CRLA 22 of 2012 and JCRLA 29 of 2012.
Pardon to mention, my appellant.
Special vehicle list, old matter item number 3.
Not, I might pardon, on behalf of Mr. Rao,
Mhm.
can it be taken up tomorrow because he could not trace out the file and also he's out of cutter.
All right, Wednesday.
Any day, my lord.
All right,
Tomorrow, day
Wednesday.
after tomorrow.
Day after, day after. All right. At the request of Mr. Day after.
Special vehicle list item number 4. Special vehicle list, old matter item number
No
3.
instructions dismissed. All right.
I might pardon,
Special
on
vehicle
behalf of
list
Mr.
item number
Rao,
5.
can it be taken up tomorrow
I don't
because
find
he
no
could not
instruction.
trace
No
out the file and also he's out of cutter.
All right, Wednesday.
Special
Any
vehicle
day,
list
my
item number
All
6.
right,
Tomorrow, day
Wednesday.
after tomorrow.
Day after, day after. All
Your
right.
Lordship may see the
At
last
the request
order.
of Mr.
The state is the
Yeah.
petitioner, my lord.
Special vehicle list item number 4.
File the
Special
second
vehicle list,
copy.
old matter item number
Unless
3.
the file, the it shall be dismissed.
I
My
might
lord
pardon,
Justice.
Special
on
vehicle
behalf
list
of
item
Mr.
number
Rao,
5.
can it be
State
taken up
is not-
tomorrow
I don't
because
find
he
no
could not
instruction.
trace out the
Pavitra
file and
Sahu
also he's
versus
out of
state.
cutter.
All right, Wednesday.
Special
Any
vehicle
day,
list
my
item
lord.
number
All
6.
right, which matter is day after, day after. All
Your
right.
Lordship may see the
I hope
last
you're in the
order.
right list. What is the name,
The
number of your
state is
matter?
the
Yeah.
petitioner, my lord. Actually, I didn't
Special
have
vehicle list
clarity.
item number
File the
4.
No,
Special
second
vehicle
there are
list,
two
copy.
old
lists.
matter item number
Unless the
3.
file,
It
the
should be
it
appearing in the
shall be
right list,
dismissed.
right
My lord
matter, not in the
Justice.
wrong
On behalf
matter.
of Mr. Rao,
Here,
can it
state
be
is not the
taken up
petitioner.
tomorrow
I don't
because
find
he
no
could not
instruction.
trace out the
Pavitra
file and
Sahu
also he's
versus
out of
state.
cutter.
Executive
All
engineer,
right,
my lord.
Wednesday.
Special vehicle list item number
All
6.
right, which matter is day after, day after. Item 6.
Your Lordship may see the
I hope
last
you're in the
order.
right list. What is the name, number of your matter? Yeah.
Petitioner, my lord.
Six.
Actually, I didn't
Special
have
vehicle list
clarity.
item number 4.
Right.
The second
There are
copy.
two
Old
lists.
matter item number
Unless the
3.
file,
It should be appearing in the right list, right
My lord
matter, not in the
Justice.
wrong
Special
matter.
list item number 5.
Here, state is not the petitioner.
I don't find no
Dated
instruction.
7 Pavitra Sahu versus state.
Executive engineer, my lord.
Wednesday.
Special vehicle list item number 6.
All right, which matter is day after, day after. Item 6.
Your Lordship may see
No,
the
no,
last
second
order.
copy is what is the name, number of your
Petitioner,
matter?
petitioner, my lord.
Six.
Actually, I didn't
Special
have
vehicle list
clarity.
item number 4.
Right. There are two lists.
Item number
Unless the
3.
file,
It should be appearing in the right list, right matter, not in the wrong
Special list
matter.
item number 5.
Here, state is not the petitioner.
I don't find
Dated
no
7
instruction.
Pavitra Sahu versus state.
Executive
It's already allowed as against 1 to 5, 7, 8, 10 and 11.
Your Lordship may see
No,
the
no,
last
second
order.
copy is what is the notice written on stand allowed so far as this is 1 to 5, 7, 8. There are two lists.
Item number
It should be appearing in the right list, right matter, not in the wrong matter.
item number 5.
Here, state is not the petitioner. Dated 7 Pavitra Sahu versus state.
Executive
It's already allowed as against 1 to 5, 7, 8, 10 and 11.
Your Lordship may see
No,
the
no,
last
second
order.
copy is what is the notice written on stand allowed so far as this is 1 to 5, 7, 8. There are two lists. It should be appearing in the right list, right matter, not in the wrong matter.
Item number 5.
Here, state is not the petitioner. Dated 7 Pavitra Sahu versus state.
Executive
Already allowed as against 1 to 5, 7, 8, 10 and 11.
Your Lordship may see
No,
the
no,
last
second
order.
copy is what is the notice written on stand allowed so far as this is 1 to 5, 7, 8. There are two lists. It should be appearing in the right list, regularization for even skilled laborers using emphasis. We are also not on the question of
the workman as to at what rate the NMR should be paid and whether they should not be paid at the rate at which regular workers doing the same type of work was not even equal pay for equal work is not a disease to the question. This was not the issue for the Honorable Court in 871 of 91. This was not decided. It was left open. Subsequently, we are also not on the question of the workman as to or two batches of workers and whether they should the president of the NMR, they approach the OIT. The OIT then paid certain reliefs. Those reliefs, this was not the issue for the Honorable Court in 871 of 47 of 93 and 57 of 54 of 93, where the present opposite party was not who are added as 211, they were not parties. The president of the OIT then laid down certain OIT then due to a paid certain reliefs. They are not they were not parties before the OIT. Subsequently, much later in 2007, they moved to 93 and 57 of the OIT. The OIT then said the present office not made any representation at that point. Who are added as now they were not parties to make the representation. The OIT then laid down made the representation. There was no rejected. That is why the reliefs mandate. When the representation was rejected, without challenging that rejection order, my when they moved over this honorable, they went to the Labour Court where then the Labour Court never examined all this concept and the 2002 judgment that you make a determination. There is no determination of any claim. There is no determination of any claim.
or an order of a tribunal or a court or something, there has to be, first of all, a determination of a claim. And then you go to the 33C2 and say, this is how it should be computed and whatever. This is what I need to, therefore, get.
In fact, the Learned Labour Court has presumed that there is an inequality of wages without having come to an award. And then they have tried to justify means of the deposition.
So what you were reading at page 21,
my lord,
that's a writ petition filed by them.
Yes, my lord.
Oh, in which it was clear that there was no issue of equal pay for equal work. And
the court was very clear as to what issues were in force at that point of time and what was decided. And 2002, in fact, if they had filed at that point of time, they would have succeeded. 2002, there's a very clear judgment which came from the apex court. That is also annexed. Now, that is at page 69.
Yes.
I'll first draw my lord's attention to the relevant paragraphs. It's a long judgment. Page 65 first. Because there was an entire plethora of cases that were considered distinguished and then this was delivered. Page 65 from the middle of the page.
So what was the occasion for the state to go before the Supreme Court?
Because there was a large, these are all irrigation projects. In those irrigation projects at that point of time, 1970s and 80s, there were about 15,000 NMR workers who were working in various projects. Now, those were all tenure-based appointments. So once a project is over, these workers had to be disengaged. Now, because there are a lot of simultaneous irrigation projects going on at that point of time.
So they would be transferred from one project to the other.
So that was the issue, that if you are retrenched from one project after the project is complete, could you be absorbed in other projects? So for that purpose, the High Court, the Honorable High Court had allowed their claims, against which the state had gone to the Supreme Court. And that's where this entire judgment was delivered. So my lord will see at page 65, the second part.
Yes.
I'm reading from the conspicuous omission.
Yes.
the conspicuous omission either to refer to or deal with and consider any question based on equal pay for equal work to workers, even as they stood employed as NMR workers, advert to or notice any one of the decisions elaborately considering the other decision reported in Jasmeer Singh, so as to the principles to be applied before doing so, would inevitably go to show that the questions of the nature exhaustively considered and decided in the later decision reported in the Jasmeer Singh were not at all the subject matter for consideration or decision in the Chief Conservator of Forest case. So they have gone through all these case laws, and the next page, my lord, will see, page 66. The decision reported in Pyare Singh is no authority for the proposition that temporary, ad hoc, or daily wages like NMRs should be treated on par for purposes of pay scales with the regularly employed permanent staff in the establishment, and merely envisaged a serious and sincere effort on the part of the state to regularize such casual laborers or work-charged employees as far as and as early as possible, subject to their fulfilling the qualifications, if any, prescribed for the post, and subject also to the availability of the work, meaning thereby the post as well as scope for providing employment. In paragraph 42 of this judgment, this court, while setting aside the direction of the High Court, observed as follows, and so and so. I'm not placing that part. I'm placing the on page 67 after the quotation. Though equal pay for equal work is considered to be a concomitant to Article 14, as much as equal pay for unequal work will also be a negation of that right. Equal pay would depend upon not only the nature or the volume of work, but also on the qualitative difference as regards the reliability and responsibility as well. And though the functions may be the same, but the responsibilities do make a real and substantial difference. After having discussed everything, the operative portion is page 69. For the reasons stated above, the appeals are allowed, and the orders of the High Court are set aside insofar as the pay equal to that of the regular employed staff has been ordered to be given to the NMR daily wage casual workers as indicated above, to which they will not be eligible or entitled till they are regularized and taken as the permanent members of the establishment. For the period prior to such permanent status regularization, they will be entitled to be paid only at the rate of the minimum wages prescribed or notified. It is more than that what they were being paid as ordered by this court in Jasmeer Singh's case. There will be no orders to pass. So very clear. So if they had approached prior to this judgment, they had a case. After this judgment, there was no determination whether of what their responsibilities were. They did not even approach the labor court directly. In fact, they actually approached the OIT. After the OIT had rejected the representation, they are supposed to have challenged that before this court. They did not do that, but approached the labor court, wherein the appeal order has been passed. Yes, please.
We have only claimed the minimum wages as my learned friend said. Let them determine once again, my lord, what should be my minimum wages. What is my claim as for the minimum wages applicable to the NMR, and the differential amount may be paid to us. If my learned friend is relying on
so
this.
You also want to make a representation for that, whatever for what he's worked.
My lord.
Can he make a representation?
They already made a representation.
I see.
That was rejected. They did not challenge that. Instead, they went to the labor court. So the labor court were not seized of the primary issue.
Oh,
If they had espoused that issue before the labor court, it would have occasioned a chance for the labor court to have decided on the issue and then come to this finding. But that has not happened. It's directly an application under section 33C2.
No, but suppose he withdraws, he wishes to go to you again, irrespective of the labor court. We set aside the labor court award.
My lord.
Can he still make a representation to you? Because these are LRs of the deceased workmen.
If the court wants, yes. But that representation was made in 2007 and rejected. If they want to approach again, we have no such.
As your lordship pleases, my lord, what more I can say? Only thing, poor people, my lord, they have claimed only some amount. Nothing that towards their wages and the minimum wages.
What is the reason for rejection? Only that they did not approach. They
were not parties before the court.
So what? Still
500
that claim on merits should be considered.
561 plus 81 NMRs had approached.
I know, but so what? If they did not approach, then
they can approach once again, man. They are a liberty to approach.
All right. The executive engineer has in this petition. Executive engineer, Telangiri Headworks Division, Koraput, has in this petition challenged an award passed with the labor court. Koraput. Sorry, Jaipur. Koraput, in ID in this case number 38 of 2008, under section 33 capital C bracket 2 of the Industrial Disputes Act 1947 bracket ID Act, whereby the Labour Court has directed page is that? Which page is that?
The Labour Court's decision, ma'am?
Yes,
Uh,
page
no,
75, right?
At page 73.
Starts at 73.
Ma'am.
To pay rupees 20 lakhs 04422 to the petitioners who are 9 in number. No, but now it's been allowed. Your petition was allowed vis-a-vis all the other opposite parties except 2.
Because of
This is
substitution.
the total sum of 19 lakhs for all of them, correct?
All of them.
So to these 2 opposite parties, it will be much less.
Ma'am.
As per the calculation sheet filed by the opposite parties here, who were non-muster roll bracket NMR bracket workers from 1977 onwards. Paragraph. While directing notice to issue in the present petition, on 17 February 2011, this court stayed the operation of the impugned order. Paragraph. Subsequently, by an order dated 28 February 2011, at the request of opposite parties as agreed to by opposite parties 1 to 5, 7, 8, and 10 to 13, the present writ petition was in fact allowed, and the impugned award of the Labour Court was set aside. Full stop. The petition was continued only as far as the legal representatives bracket LRs of the deceased opposite parties 6 and 9. Paragraph. The court has heard the submissions of learned counsel to the parties. It is pointed out by Mr. Naik, learned counsel for the petitioner, that opposite parties 6 and 9 had earlier approached the Orissa Administrative Tribunal in OA number
1542 of 2007.
Where are those details which you were reading out?
The order is at page 54 and 55 of the tribunal.
No, that's right. No, you were reading out a written statement kind of a thing.
Ma'am, written statement is at pages 51 and 52.
Earlier you say the opposite parties. No, you say as regards the Telangiri Headworks project, the present petitioners, the present opposite parties had filed OGC case number 871 of 1991. While disposing of the said writ petition, by the judgment dated 6 March 1992, this court issued certain directions for their absorption in other projects. Interestingly, in the aforementioned judgment of the court, it was specifically stated that the said petition did not involve the question of either regularization of the NMRs or of equal pay for equal work performed by their contemporary regular workers. Full stop. Agreed by the above judgment dated 6th March 1992, the state filed civil appeal number 7342 of 1993 and other connected appeals in the Supreme Court of India, which came to be allowed by a judgment dated 29th October 2002. Holding that the NMRs would not be entitled for equal pay to that of regularly employed staff till they were regularized and taken as permanent members of the establishment. However, it was held that, open quotation, they would be entitled to be paid only at the rate of the minimum wages prescribed or notified, unquote. It appears that pursuant to the said judgment, a representation was made by the present petitioners. While some of the NMR workers filed applications in the Orissa Administrative Tribunal, being TA number 47 of 93 and 54 of 93, correct? Well, the present applicants, the present opposite parties were not petitioners in either of those applications. The present opposite parties filed a representation dated 22nd March 2007, which was rejected in view of the judgment of the Supreme Court. Full stop. According to Mr. Naik, their representation is rejected only because they were not parties to either TA numbers 47 or 54 of 1993, correct?
47 of 93 and 54 of
1990. Full stop. Paragraph. It is seen that the present opposite parties straightaway approached the Labour Court with a petition, with an application under Section 33, capital C bracket 2 of the ID Act, notwithstanding the rejection of their representation. Full stop. They computed certain amounts due to them and the solitary witness examined by them was not cross-examined by the present petitioners. On that sole ground, in the impugned award, the Labour Court allowed the application and issued a direction as noticed herein before. Paragraph. Learned counsel, the petitioner is right in his contention that without there being actually a determination of a claim by the tribunal, the Labour Court could not have straightaway entertained an application under Section 33, capital C, bracket 2 of the IDD Act. Stop. The law in this regard is well settled. Let's leave a space for that. There's a judgment of Justice M.R. Shah, a very recent one, where he's reiterated that. You have it? All right. Consequently, this court has no hesitation in setting aside the impugned award insofar as it directs payment of the determined wages in terms of the calculation filed by the opposite parties 6 and 9. Full stop. Nevertheless, their claim for minimum wages as directed by the Supreme Court of India in the judgment noted herein before will still have to be considered on its merits by the present petitioners, notwithstanding that they may not have filed either OA number. They may not have joined the applicants in OA number and TA numbers 47 or 54 of 1993. Paragraph. If the opposite parties, LRs of the opposite parties 6 and 9 make such representation for payment of minimum wages for the work actually performed, not later than 5th September 2022, it shall be considered on its merits by the present petitioners, notwithstanding that they may not have been party to TA numbers 47 or 54 of 1993, and consider such representation afresh, notwithstanding rejection of an earlier representation, and communicate the decision to the LRs of opposite parties 6 and 9 within a period of 3 months thereafter.
Make one submission, my lord. Minimum wages as notified by the state government is already being paid to them.
So if you deal with that in the representation, the petition is disposed of in the above terms.
Special weekly list item number 7.
My lord, may I please be withdraw this appeal, your lordship, with a liberty, your lordship.
There's no liberty, sir. It's a 2012 matter.
Only thing is that, your lordship, I'm agreed by there's a blanket order of without issuing notice. If your lordship will see the last person, admitted thumb impression of the plaintiff mother available in future. In these 10 years, they have see the plaintiff has not produced such evidence, your lordship.
I'm not understanding what you're saying, sir.
Page 16. I'm agreed with only that it's a order has been given that if any, in the event of any occasion, there would be an admitted thumb impression of the plaintiff mother available in future, the rejection present impression would not be barred. In these 10 years, he has not produced any admitted thumb impression, your lordship. Only I am agreed with this thing. If it's in future, it's 10 years, he has not taken benefit of this order.
I don't understand what he's saying. What's wrong with this?
My lord, the application under section 16 rule 1 has been rejected because that is comparison with the under section 73 evidence act. She has to admitted thumb impression because she is disputing the thumb impression of my documents, which has been registered documents in 1968, and therefore she is producing an will, and we are disputing that. And she then she is trying to call for the application is to call for the from the sub register to compare. But how to compare the impression, because all the two documents are thumb impression be disputed. Because there is no admitted for
There's nothing allowed. Actually, the only order is innocuous. It says if there's such admitted thumb impression
In
available in future,
future. Yes, Lord. In
Ah,
the
so-
future,
has any such admitted thumb impression emerged?
till that he has not put.
Then what is your problem? Then what is your problem? You have nothing to be aggrieved about having perused the impugned order of the learned single judge, where the only relief granted to the respondents is that if there's an admitted thumb impression of the mother available in future, a fresh prayer can be made by the respondents. Stop. The counsel for the appellants states that till date, no such admitted thumb impression of the mother has emerged. That view of the matter, there's no occasion whatsoever to interfere with the impugned order of the learned single judge. The writ appeal is dismissed.
Special weekly list item number 8.
It may please your losses, my lord. I have challenged the judgment of honorable single judge, rejecting my writ petition on the basis of a wrong judgment which is not applicable to my case. Well, the petitioner filed the writ petition challenging the rejection of
Even
it-
at the time of the single judge's order,
Yes,
the selected Anganwadi worker had been working for 13 years.
yes, my lord, working for 13 years.
And now must be having worked. Now, single judge's order was 2011, 12.
12.
And one more, 10 more years, you add, become 23 years.
Yes, my lord.
Why
That
should
can-
at this stage interfere after she has been working
My
for
lord,
23 years?
My lord, the Honorable Supreme Court held in 2005 and other cases, my lord, I have brought the citants. If the selection is illegal and somebody has been selected on the basis of wrong, my lord, recruitment process, long continuance will not give a right to him.
23 years is a long, very
20
long
years,
period.
20 years, my lord.
23. It was 13.
That no, she was appointed in 2002.
Anyway, okay.
2002.
2002 will still make it 20 years.
And that was subject to her appointment was subject to result of the writ petition.
Whatever, still 20 years.
Anyway,
Anyway,
long
tell us on merits what it is.
yes, on merits, my
Ah.
lord.
My lords, just
Let me place.
no, just the file, my lords, is not. There's some issue with the office, so the file could not be traced. My lords, will keep it on some other day, so I can get the file.
This Anganwadi worker is a major dispute in Orissa.
Yes.
No, my lord, here in Orissa, that is a major dispute.
Ah.
Your lordship will know the poverty of the Orissa.
Correct, correct. So jobs
In a
are very
villa,
difficult to
job
find.
is required.
Correct.
Number of persons there.
Correct.
My lord, only sole point is there, my lord. Only
No,
one
he doesn't
point.
have file. So we'll have to adjourn it. You say counsel for the state states that the file has been displaced and seeks a short.
Your lordship, day after tomorrow, my lord, also.
Next week we'll
That
have.
is long years, my lord. It was listed again and again. It could
No,
not
16th. We'll have done
Prior
16th.
to your lordship's tenure, my lord. I tried to dispose of the matter immediately, but
I know.
not with them.
16th.
My lords, give me the liberty.
13th, my lord.
16th, sir. 16th.
My lords, give me the liberty to get the file from the registry upon paper.
Yeah, it will be open to the state to collect a soft copy of the entire appeal on a pen drive from the registry.
They have applied only new guidelines, my lord. Advertisement application was prior to that. I was rejected on the ground that I have not attended the age of 21 years. Previous age was 18 years, my lord. Therefore, candidature was rejected. Whether that new guideline is applicable or not.
Your client also must be now in the 40s.
40, 43, 44 is there. Another, my lord, I have 20 years service is there.
All right.
Special weekly list item number 9.
Please, your lords.
Yes.
The order under Annexure 1, passed by Honorable Single Judge is under challenge that it be relevant page here, page 13, make a glance. The settled position has been unsettled by way of this order. But after the cut-off date, the Honorable Single Judge are directed to accept the application as well as obtain the NOC. By the date of filing of application, neither the respondent institution was obtained the NOC nor any application was submitted. Page 13, make a glance. Place my lord. The petitioner in this writ petition was prayed for a direction to the opposite partner of both present appellant to accept the NOC along with the application form and require a document from the petition institution
for grant of
You're for the
permission.
appellant.
My lord,
You're for the appellant.
I am for the appellant.
Who's for the other side?
That side is
No, no.
state for
Served, not served. The
State.
order, there is a
State.
stay order.
state is for 2 to 5.
No, that's not the
Number one
contesting
is-
party is opposite party number one. Respond number one.
My lord,
If they have been served,
notice or
so they are not interested then. You say the operative direction in the impugned order of the learned single judge is that the application made by the respondent number one institution should be considered the PhD charges, which is filed by 16 April 2012. Paragraph. The above order of the learned single judge was stayed by this court while admitting this appeal on 4th July 2012. That stay order has continued ever since. Despite service, none has appeared on behalf of respondent number one. Or even filed an affidavit. Much. Full stop. No attempt has been made to vacate the interim order passed by this court. So it appears that respondent number one is in fact not interested in pursuing the matter anymore. Consequently, the impugned order of the learned single judge is hereby set aside. The writ appeal is allowed.
hello, please.
Specialist item number 10.
My lord, item 10, a file has been misplaced. My lord, a case of 2012, day after tomorrow, my lord.
No.
Any day after.
No, whenever you find the file, you file an application, we'll revise it. Concept of the appellant
My lord-
says that the file has been
My lord,
misplaced.
case of 2012, my lord.
No problem, sir. Whenever you find the file, you file an application, we will revive the appeal. All right. The appeal is dismissed for non-prosecution. It will be open to the appellant whenever the file is found to file an application for the revival of the appeal.
Special utilist item number 11.
In item 11, I am for the appellant. There is a delay of 2 days they have shown the register, but there is no delay to as
It's
per
all right.
my
So what's the matter about? Tell us.
matter is that the respondent has availed a loan, tractor loan, and the tractor was seized, whereafter he filed a suit for waiver of the debt relief schemes and the entire loan to be waived out.
What is remaining in this matter, sir? For 10 years, nothing has happened in this appeal. Nothing has happened. The single judge's order must have worked itself out.
I have filed the appeal with regard to expunging the adverse remark against the bank.
What adverse remark? Nothing. There's nothing in this. The only direction issued by the learned single judge to the present appellant bank is to release the tractor immediately in favor of the respondent on an undertaking being given by the respondent that he will not dispose of the tractor till disposal of the suit. Full stop. Clearly, that order has worked itself out. In the present appeal, no order has yet been passed in the last 10 years. Paragraph. Consequently, the court sees no purpose in entertaining the present writ appeal and it is disposed of as such. Right.
Special utilist item number 12.
Executive engineer.
Item 12.
None appears dismissed no prosecution.
Special utilist item 13.
Item 13 permitted to withdraw.
All right. Concept of the appellant seeks leave to withdraw this appeal. Dismiss this withdraw.
Special utilist item 14.
14, my lord, is in practice. 14 is in practice. This is disposed of as such.
Special utilist item 15.
None appears dismissed no prosecution.
Special utilist item 16.
For the respondent workman, my lord.
All right. None appears for the appellant. Dismissed no prosecution.
Special utilist item 17.
May I please, your lords? My lord, the petitioner was appointed as a Hindi teacher in Maha Maheshwari High School and 25/6/1992. After performing her duty for some time, she was prevented by the headmaster of the school to discharge her duty. Thereafter, the petitioner approached the secretary of the school and other authority, but our grievance has not been considered. Petitioner preferred an appeal before the joint director of school, and the joint director allowed the appeal, directing to reconsider and to absorb the petitioner in a formal post of Hindi teacher if the post is still lying vacant and she is found suitable considering her past service rendered in the said school. That is Annex 2, my lord.
Sir, this you have an alternative remedy under the State Education Tribunal Act.
My lord, we had preferred an appeal. Education Tribunal also allowed, but the headmaster didn't allow us to join in the service. Accordingly, we filed a read page 5, my lord, para 13, your lords may kindly see. I have quoted that order. This honorable court directed to prefer an appeal again before the joint director.
And then
Yes.
what happened?
Thereafter, we prefer an appeal. Still then, no consideration was made.
No, but against the joint director's order, you have to go to the tribunal.
My lord, that is at page 5, my lord.
Against that order, you have to go to the tribunal.
And I prefer to the joint director order, my lord. Appeal was preferred.
No, the joint director dismissed your appeal.
Yes. No, joint director, my lord, yes. May I allow appeal, my lord. Allow our appeal.
So you're the petitioner here. If he's allowed your appeal, why are you here?
My lord, in spite of the order passed by this joint director, the headmaster didn't allow us to join in a service. Annex 2, my lord. And in place of us, another person was appointed. Later on, he was terminated.
Come to para 6 of the...
Para 6, my lord?
Yes.
That petitioner was continuing his service in 25/6/1992.
No.
My lord.
Of the reply, sir, of the counter affidavit.
Counter copy they have not served, my lord.
It's already infructuous. You just show him a copy of the counter.
Counter copy they have not given.
It's already infructuous. It's already been considered pursuant to the order.
Private opposite party number 6. Who has been appointed as whose post has been granted has been released in his favor. He has been cited as opposite party number 6 in the present petition.
My lord, that para 6 we have challenged, my lord, that order.
Everything can't be challenged. Just come to read para 6. You never challenged that order.
That is reliably learned by this deponent that the managing committee of the school reconsidered to absorb Srimati Sahu in the post of Hindi teacher by resolution number 2211/2006 on the grounds stated therein that she has never challenged the said resolution of the managing committee. Rather, she has approved this honorable court for implementation of that order 24/8/2005.
So 24/8 does not survive because after that the managing committee has already passed a resolution.
Passed a resolution in appointing the present petitioner, my lord.
No, but which you have not challenged.
No.
The present petition was filed in 2012, sir.
My lord, that person who was appointed in place of this present petitioner, he was removed from that said post, and the managing committee has appointed the present petitioner, my lord. If the managing committee has appointed us, then why should we challenge this?
The 2009 granted order also shows that OP number 6 has been his favor granted has been.
He has already been removed from his service, my lord.
That there is no such material.
My lord, he is removed at Annex, my lord. Annex 3, my lord. By the managing committee. Page 16, my lord.
The state, what is the stand of the state? You have not filed any reply.
No, counter has not been.
So what is your stand?
I will take instruction from my grant.
There is a stay. She's continuing as a result of a stay, I think.
My lord.
For the last 10 years, she's working on a stay order as Hindi teacher.
My lord, grant me just one week time.
So her purpose has got stayed. I mean, was served. So by an interim order, she got the final relief. The final relief was that she should continue her duty as Hindi teacher. By stay order, she's been continuing.
No, whether she's continuing or not also, that I will take.
No,
She's continuing, my lord.
Ah,
I don't have.
he's the petitioner, he will know.
Yeah,
No, my lord,
And
I
this kind of a thing, when there's an interim order allowing her continue, why would she not continue? She'll obviously continue.
I will take instruction on that.
Counsel for
10
the
days time.
Education Department states he's not aware of the current status and requires time to file an affidavit. Paragraph: the affidavit be filed within 4 weeks, rejoined with the next state interim order to continue.
Right.
From 19th October.
Special legal list item number 18.
Item 18 is not possible.
All right, pass over.
Special legal list item number 19.
19, my lord, no instruction, my lord. I pray that if any cause option
No,
arises.
not 2012 matters. Counsel, the petitioner states he has no instructions.
Beg your pardon, your lordship. Item number 19, last matter. WPC 10,628.
Yes.
I beg your pardon, your lordship. I'm appearing in VC due to the.
Yes, carry on, carry on.
Your lordship, initially the petitioner had applied for allotment of the additional land under annexure 6 in 2009. Thereafter, the government was pleased to issue a direction demanding an amount of 4,13,220 under annexure 7. And after that, the petitioner has deposited an amount of 4,13,220. But all of a sudden, there was the order of the GA department under annexure 9 on 31st December 2009 that there is a revision of the premium. But meanwhile, by that time, we had already deposited the additional premium for the additional land amount.
So this is land in the heart of Bhubaneswar.
Yes. Yes, your lordship.
What is the current market value?
But your lordship, I may be pardoned that due to no fault of mine,
so,
there was a demand.
Sir, due to no effort of yours, that market value is shot up.
No,
you're sitting on a gold mine now.
No, pardon,
Yes,
your
yes.
lordship. Actually, I had deposited the amount. I had deposited the amount as per the direction of the state government.
Very well.
And meanwhile, the state also, even though there is a direction of the honorable court to file counter, the state has remained silent on this matter.
Right. This revision on premium and all, we are not interfering at all. The market value has gone up so much. This for the last how many 10 years you enjoyed a stay?
Your lordship, we had already been allotted direction for allotment of the additional land. Additional land. Basing on that, we had deposited the premium amount. So there was no cause of action for the government to sit over the matter.
Yes. Now you pay the remaining. You have to now pay how much as per the original demand? How much have you to pay? Some 4 lakhs odd.
Yes, your lordship.
You pay that, and they'll consider your case for
My lord,
execution of lease.
the valuation of the land at Ganganagar for 10 square feet, it will be 4 lakhs.
That's what I know. This is heart of Bhubaneswar, sir.
This
They
is
all
near
enjoyed a stay.
airport gate, just in front of airport, Ganganagar.
Because speculative.
That is not near the airport. It is near the governor house. And
very good, sir. That's even more. Even more.
Fault of mine, I'll be penalized, your lordship.
What is penalized? You're sitting on a gold mine, sir.
I had
no penalizing.
It is in record, and the state government needs to file a counter in this effect.
No need, sir. We're not interfering with all this. You see,
direction, your lordship, that was
agreed by a demand of enhanced premium pursuant to a cabinet decision dated 14th December 2009. The petitioners who are occupying land in plot number 14 bracket SCR unit 6 Ganganagar Bhubaneswar have filed the present petition.
Beg your pardon, lordship. Just one thing I want to submit, that additional land is in front of my plot, and once that additional land is allotted to some other person, I lose my easement right. I will have no way.
That is a different issue altogether, sir. We are not on that. That's a completely different issue. Whether you get an easementary right or not, you have to approach the government for those things.
Oblige your lordship.
Paragraph. The council, while directing notice to issue in the present petition on 6th August 2012, this court stayed. Directed status quo to be maintained. That stay order has continued for 10 years now. As a result, without having to pay the enhanced premium, the petitioner is continuing in the land pursuant to the allotment order dated 26/11/2009. Having heard learned counsel of the parties and taking note of the fact that the present market value of the land in Bhubaneswar, particularly in the area in question, has enhanced multifold. There would be no prejudice whatsoever caused the petitioners in paying the enhanced premium as demanded at the time when the present petition was filed. So therefore, the court is not inclined to interfere. The interim order is vacated. The writ petition is dismissed. And the others, you say no instructions, dismissed, interim order is vacated.
Special legal list item number 20.
May I take your lordship? Lordship, may kindly see order number 7, dated 5th of October 2012, ballot. Ballot, paragraph 3.
Yes.
It is brought to our notice by the learned counsel for the petitioner that on account of the enlistment of the petitioner's name in the rejected list C, the petitioner company could not be able to get necessary certificate for presentation of its papers before the concerned authority, except Jharkhand State Pollution Control Board, which according to the petitioner, the Jharkhand State Pollution Board has accepted the petitioner company to present its papers before the concerned authority on account of the fact that petition is pending before this court. Though sufficient opportunity was given to the opposite parties, learned Assistant Solicitor General is unable to take instruction in the matter and file its counter either with regard to the merits of the case or interim prayer made in this case. Having heard learned counsel for the parties, we are prima facie satisfied that the ground for enlistment of the petitioner company in list C is not correct. Therefore, we direct the opposite party to make arrangement to permit the petitioner to present the research papers regarding environmental clearance before the Environmental Appraisal Committee, constituted under the policy of 2006 framed by the Union of India, represented by the Ministry of Environment and Forest, and also permitted to make representation before the State Environmental Committees plan. But because of this, I have been presenting my the presentations plan, and it was really carried out. Now, in 2022, I do not know whether it has been changed or something, whether the list has been approved or upgraded. So, what I pray, my lad, let this litigation be disposed of, my lad. If the cause of action survives, I can approach again.
All right. You say, counsel to the learned senior counsel to the petitioner states that the order dated 5th October, pursuant to the order dated 5th October 2012, the petitioners was permitted to present its research papers before the appraisal committee. Full stop. It seeks leave to withdraw this present petition with liberty to seek appropriate remedies if any cause of action survives. The petition is disposed of, withdrawn with liberty is paid for.
Appearance we have noted.
All
Yes.
right.
It's a legal list item number 21.
Liberty to withdraw this matter with liberty laws.
Liberty, what's the 2012 matter, sir? Counsel, the petitioner seeks leave to withdraw this petition. Dismissed this week.
Special legal list item
My
number
presence may be noted for OP3, TDV.
All right. All right.
22.
Presence be noted.
Yes.
Item number 22.
Let the petitioner here is the purchaser of a piece of property. On the basis of a pre-existing approved plan, he has raised construction. He had some issues with his neighbor with regard to construction and some other issues. Now that since 2012 we are in 22, Lordship may relegate me back to the authority. I'll approach them and
Or counsel for the petitioner seeks leave to withdraw the present petition with liberty to approach the authority for appropriate reliefs. This post of is withdrawn with liberty is paid for.
that is opposite part number 2.
Yeah. Or bracket opposite party number 2.
Grateful.
All right. It's disposed.
There is a contempt petition.
Contempt petition is disposed of.
Contempt is dropped.
Right. This is the third petition also disposed of in terms of the order passed today in the first petition.
Special request item 23.
23, my lord, brief has already been transferred.
Counsel, the petitioner states that it's already been transferred.
I am appearing for opposite party. I am absent from the headquarters.
All right. He's anyway saying the brief has been withdrawn. None appears for the petitioner. This was not prosecution.
Special request item number 24.
24, my lord, on behalf of Mr. Panda, I bring for passable, my lord.
All right, pass.
Special request item number 25.
25, may I please your lordships? My lords, may kindly have a glance at the list of dates and the written note of submission which is on record. In the present case, in the year 1999, I was engaged as a casual workman under the textbook production and marketing Bhubaneswar, and I continued till 26.
What is the item number?
25.
Aparna Chayani.
I'm sorry, Manoj, sir. 25 is
25, my lord, I have filed this application challenging the imposition of fine under RTI Act, my lord.
What is the fine amount, sir?
Imposition of fine of rupees 25,000, my lord.
What is there, sir? 25,000 is nothing. What is 25,000 in today's rate?
No, nothing. I have already been retired, my lord. But that imposition of fine is illegal. That is wrongly imposed, my lord. Because, my lord, on 23/7/2010, the OP5 filed an application under RTI Act seeking certain information. That was given, my lord. All the information which was
How much delay? How much delay is the question?
Delayed, man. That is, he further when he received the application before the he verbally approached the deputy commissioner for receiving more information, man. That was also given, my lord. But he filed an appeal before the first appellate court seeking some other
More than
information.
100 days, sir. Para 5. Come to para 5, page 44.
Page 44.
Delay is more than 100 days.
In response to so-called notice upon a Chairman, Tech Dorga BNC has submitted her written so-called memorandum in which she has submitted the fact that due to her engagement in his household census and population census work during the period September 2010 to March 2011, she could not find time to furnish the balance information to the appellant. Yes, my here I want to state that, my lord.
You are not reading the whole paragraph. That's the problem.
11. She could not find the time to furnish such balance information to the appellant. From her own submission, it is evident that there is being no such other pressing engagement after March 2011. She could have very well furnished the information to the appellant. As it seems, the direction of the first appellate authority has been brushed under the carpet. In the opinion of Commission, the gross negligence and deliberate inaction of the PIO.
Because you furnished this information December. From March to December, you delayed it.
Yes, sir. That is in respect of further information, my lord, which was not included
now,
in your
the more you argue on this kind of facts, the more and more you argue, we are tempted now to increase the fine.
No. I'm not.
Fortunately for you, under the Act, the maximum is 25,000.
I have already been retired, my lord.
No. Fortunately, the Act is maximum is 25,000. You see, there's a delay. There was a delay of well over 100 days in furnishing information under the RTI Act to the applicant, for which the maximum possible fine of ₹25,000 has been levied on the present petitioner by the impugned order of the State Information Commission. Having heard and consulted the parties, the court finds no error whatsoever committed by the SIC in levying the above penalty amount. There is no merit to the present petition. It's dismissed as such.
Obliged judge.
Special
The
utility
name of
item,
Mr. B.K. Das may be recorded in this.
Or-
case.
item
Obliged
20
judge.
26.
for opposite party number 5.
Item 26.
May permitted to withdraw.
Counsel petitioner seeks leave to withdraw this petition, dismisses withdrawn.
Special weekly list item 27.
57, that resumption of land law. The petitioner has purchased the land way back in the year 1995. 3B proceeding was initiated without giving any notice. And whereas
All right. Counsel, the petitioner states that the petitioner purchased the land in question from the original lessor by a registered sale deed dated
30th 5 1995.
30th May 1995, whereas the impugn order
On
was
30th
passed by
June
the
2003.
Tahsildar Bhubaneswar in WL case number 1421 of 1971 on 30th June 2003 without notice to the petitioner. On that short
1421
ground,
of 74.
sorry,
WL case number 1421 of 74.
right. 74. All right. On that short ground, the impugned order dated 30th June 2003 is hereby set aside. And WL case number 1421 of 1974 is restricted to the file of the Tahsildar Bhubaneswar.
Additional Tahsildar.
Or additional Tahsildar.
He has
Yes,
passed the
that order has been passed by the additional.
Okay, additional Tahsildar Bhubaneswar for being proceeded with in accordance with law after hearing the petition. For this purpose, the above case will be listed before the additional Tahsildar on 19 September 2022, on which date the petitioner will appear along with a downloaded copy of this order. The additional Tahsildar is directed to proceed in accordance with law and dispose of the above WL case within a period of 4 months thereafter. Till such time, status quo will be maintained by the parties.
Weekly list item 28.
Date, may I please, Your Lordship? Sorry, my lords, for so there is a list of dates and a note of submission which is on record. Your Lordship may kindly see that. In challenging the order passed by the learned presiding officer, Industrial Tribunal, dated 3/1/2012. Well, it's my list of dates starts with on 8/3/1999. I was engaged as a casual workman under the textbook production and marketing, and I continued till 22/9/2008 and was receiving wages on daily wage basis. On 22/9/2009, I was retrenched by the management. On 4/6/2010, the conciliation proceeding report was submitted by the conciliation officer DLO, and it failed. Thereafter, the conciliation report, I moved before the learned presiding officer, and 3/1/2012 is the order which is under challenge. The learned presiding officer passed an award stating therein that the management is held liable to pay to rupees 1 lakh to the second party, that is the present petitioner, as compensation, and the management is to implement the award within a period of 2 months of its publication. Now, I'll be fair enough, my lords. I have no instructions with respect to this compensation amount. What I pray before my lords is that there has been non-compliance of section 25F and 25H to that effect. This is because in 25H, the juniors who are 10 years junior to me, they are now continuing with the services back then. And I had completed 240 days of work in each of the calendar years, starting from 1998 to 2008. I'll straight away place, my lords, the rejoinder in which I have made out some factual.
You are a daily wage worker.
Yes, my lords. Now, the two issues which were framed by the learned tribunal was that whether the dismissal without complying section 25F was illegal, and second is whether I'm entitled to any relief as such. Now, the first issue was answered in my favor in the order of the tribunal. I'll just. The second issue, my lords, which they say is that I'm not entitled to any compensation in view of the judgment of the Honorable Apex Court, whereas the Honorable Apex Court judgment was in different context. It was for a workman who was engaged for 1 year and had 240 days of service, whereas I have engaged for a complete period of 10 years and 240 days of service was rendered by me in each calendar year. So, my lords, I placed paragraph 7. 7 and 8 most strictly 8, my lords, of the rejoinder.
What
When
about this 21895? Is it tagged with this?
I beg your pardon, my lords.
It's disposed of. The management's writ petition was
That
dismissed
management
or what?
petition, sorry, my lords, I
Can't. Let's see that.
I'm sorry, my lords, I don't have that. 2568 or 2000.
2568.
Just file the management.
On Dr. Debabrata Thursday now. 2012.
2012.
This compensation lieu of reinstatement is well settled, sir. It's not a mandatory requirement that every time the violation of 25F is found, there has to be reinstatement.
Let's view of the fact, my lords, it's
It's a very
25.
detailed order passed by this court dismissing the management's writ petition on 4th March 2015 itself.
Yes, my lords.
Why should we interfere? There's already an order upholding the award. The management's writ petition challenging the very same impugned award of the Industrial Tribunal Bhubaneswar in ID case number 74 of 2010 was dismissed by this court by detailed order dated 4th March 2015.
March 2014.
In other words, the impugned award has already been upheld in toto. Paragraph. It is seen that as far as the present petition is concerned, the grievance is only that the tribunal should have ordered reinstatement rather than a lump sum compensation in lieu thereof. Paragraph. It's well settled now in a patina of decisions that despite the termination of services being found to be illegal, the order of reinstatement need not automatically follow. So in the present case, retrenchment compensation is determined by the tribunal in the year 2011. As rupees 1 lakh cannot be said to be unreasonable. Unreasonably low. Full stop. The court is therefore not persuaded to interfere with the award, even at the instance of the worker. The petition is accordingly dismissed.
Special vehicle list item number
The
29.
Compensation, if any, they may have not given, then they may.
That, of course, sir, that you know what to do.
Item 29.
Yes.
None appears dismissal of both.
Special vehicle
Look,
item number 30.
29 is a contempt case. The state has also filed a review. That review, my lord, is the original petition was 2001, and the review was filed later after having liberty of the Supreme Court. Those papers are of 1956-57 of this entire bunch. I have to put them in order a little bit. If my lord calls this matter next week, my lord, any day, I'll be in a position to do
Is
justice.
there anything surviving these kind of matters, sir? Let's see what the original order is.
No, it's a review petition against the order of the
22nd June 2010.
My lord. The Tahsildar's orders was challenged before this honorable court as regards the land that was in question under the Estate Abolition Act of Orissa. That order, my lords were of the opinion in this honorable court that the Tahsildar's order the Tahsildar could not have resumed the land in his favor. Later, we went to the Supreme Court against that once the matter was remanded.
The review is on the basis that a Tahsildar does not have jurisdiction under the Estate Abolitions Act to pass such an order in the first place. That is supported by judgment of the Honorable Supreme Court.
No. What he seems to pass is a review of an earlier order passed by the Tahsildar. And so this court has said there's no such power of review.
No, the Tahsildar does not have even jurisdiction to decide on the position of the land, to settle the land without the concurrence of the Revenue Board. That is the finding of the Supreme Court. I have the decisions also.
This review petition you filed pursuant to the order of the Supreme Court.
My lord.
This review petition was filed pursuant to an order of the Supreme Court.
My lord.
Where's that order? Annexure 1.
My lord.
No, Supreme Court.
Order dated
This is the High Court.
9/12/2011.
Annexure
That
1
is
is
SLP.
Oh, in SLP.
My lord. That are dismissed as withdrawn. And my lord,
With the
honorable-
liberty to approach this
Right.
Honorable Court for review.
not inclined to interfere in the matter, therefore.
No, the liberty granted for file a review.
Liberty.
No, that decision, page 253,
Vrindavan Sharma. Right.
page 253, paragraph E. Paragraph E, I'm reading from under section 2D.
Yes.
Under section 2D, the collector means any officer appointed by the state government to discharge all or any of the functions of the collector under the Act. By exercising their power, the government, by notifications dated 23/8/1956 and 17/12/1956, which are later amended on 4/2/1958, appointed the Tahsildar to discharge the functions of the collector under section 6, 7, 8, subsection 3, and 8, capital of the Act. Thereby it is clear that when a claim was laid by the respondent setting up a lease said to have been given to him by the intermediary, the Tahsildar had no power under section 5I, read with section 8(1), to inquire into its correctness. Even in the case he himself is competent and decides not to set aside the lease, he should have referred the case for confirmation to the Board of Revenue. The object of conferment of such power on the Board of Revenue appears to be to prevent collusive or fraudulent acts or actions on the part of the intermediaries and lower level officers to defeat the object of the Act. So any order that was passed by the Tahsildar pursuant to settlement of the lease, whether he had no jurisdiction to pass at all, he had to refer that to the Board of Revenue. If that is wholly without jurisdiction, then the entire foundation goes and therefore the judgment doesn't. That is short point. Then, of course, the decision goes into the correctness of the patta that is given to the hukumnama, as they call it, in 52-53, just before the Estate Abolition Act came into place, on plain paper. That was also challenged. That's another issue. But this short point itself is enough.
That is, your lordship, the which decision they refer to, my lord, I am unaware, my lord, but the
Vrindavan
decision.
Sharma, you're unaware. That's the most leading
What
decision on this.
Because the decision, the recent decision, my lord.
Vrindavan Sharma is 1995 Supreme Court, not recent.
95 Supreme Court.
That's not recent, madam. 30 years, 27 years.
Your lordship, my lord, I will go through that decision, my lord. That is, but in this case, that confirmation of Board of Revenue, that is relating to the provision under section 5I, my lord. If lease has been obtained under 5I, then thereafter lease has been settled, that Board of Revenue confirmation is necessary. But under section 8(1), my lord, he was a tenant in 79,
Read with
land
8(1).
has already been
This is the
settled.
decision. The decision is 5I, read with 8(1). Yes.
But your lordship, I kindly see the judgment of this honorable court that's to be reviewed, my lord, in para 8, your lordship kindly see. That has already been discussed. That has already been settled in 79. Your lordship, para 8, your lordship kindly see. Para 8 of the judgment.
Yes.
Your lordship, para 8, may I read, my lord? The law is also tell that if no application is filed under 8I of the 8(1) of the Orissa State Abolition Act by a tenant, or if a misconceived application is filed, it is the Tahsildar who is to consider the same.
This is what is wrong, sir. This is completely contrary to the Brindavan Sharma. This is the paragraph. It is totally contrary to Brindavan Sharma.
That Tahsildar is only to inquire into the matter on administrative side under section 8(1), madam. Because whether he is a tenant under section 8(1), he is to make inquiry that whether he is in possession over that property or not. If that continues, that, my lord, that rent is to be fixed and otherwise to. Your lordship kindly say 79 order. Your lordship next page, para 8.
Yes.
Para 8, basing upon the RI report, your lordship, para 8, verified the ROR, your lordship. Verified the ROR hall and the report submitted separately, but at the time of perusal of the order sheet, we came across the document which was prepared by the Tahsildar Panpos on 16/10/84. The earlier Tahsildar settled in 79. After 17 years, another successive Tahsildar came and reopened the case by making a fresh inquiry and declined to recognize him as a tenant. Thereafter, my lord, that impugned order was challenged in this before this honorable court. So, your lordship, para 8 kindly say that at the time of perusal of the order sheet, we came across a document which was prepared by the Tahsildar Panpos on 16/10/1984 under the heading "My Observation in the Case." The entire observation is reproduced here in below. On perusal of the document filed by the parties, the report dated 12/7/76 of the RI and statement of the parties and the witnesses, beside the observation by my predecessor by the order sheet dated 23/79. I agree that the Hukumnama has been duly granted by the ex-Jamindar Kumar Munda. Perusal of the compromise petition dated so and so filed by the inspector in charge Raghunath Pali and Nilambar Patri, the present opposite party member, and witnessed by Dibakar Mahanti and others, clearly show that the disputed clause was under the position of the petitioner Nilambar Patri. The report of RI dated 12/2/76 is specific that the petitioner was all along in possession of the disputed land. I have also examined the oral evidence tendered by both the parties, as it appears that the petitioner is consistent in his statement regarding title, ownership and possession over the disputed land. The objector, although claims position over the disputed land since 1945, has not been able to produce any document so far in support of his position, whereas the petitioner has filed Hukumnama and rent receipt, and as such there is no reason to disbelieve the case of the petitioner. As regards the objector, that the objector name alert was objected over position, it will suffice to say that he has got no case. He has neither examined himself nor any witness produced by him in support of his case so far. He has also not taken any care to prove the document filed by them. Hence, I am of the opinion that I should have disposed of the case in the light of my observation above, but I feel that in order to do justice to the case, I should visit the spot and conduct local inquiry. Thereafter, local inquiry is made. Then your lordship kindly turn to para 9. That being an inquiry on the administrative side also confirms the claims of the petitioner that he was in uninterrupted possession of the land, and the Hukumnama had been duly granted by the ex-Jamindar Kumar Munda, and that too the then Tahsildar was fair enough to say that I should visit the spot and conduct local inquiry before I deliver my final order in this case. In the upper premises, the question which arises for consideration is as to whether the impending order is sustainable as indicated above. The finding recorded in the order dated 23/3/79 relating to the right title interest of the petitioner over the suit land is on the strength of Hukumnama duly granted by the ex-Jamindar Kumar Munda, as well as the physical position, and the same has also reached its finality. The matter was only kept pending for assessment of the rent on filing of the certified copy of the hall settlement records, which were also filed. Thus, there was no occasion on the part of the Tahsildar to pass the impin order negativing the findings conclusively arrived by the previous Tahsildar after taking into consideration the oral evidence. That apart, the impin order has been passed without assigning any reason and without any opportunity. Then, my lord, we can go to the extent of saying that the impin order is nothing but to review the order which was passed by the previous Tahsildar, which is not permissible, and there is no power with the Tahsildar to review the own order, resultant the impin order is quashed. So, what decision my friend is relying upon, that is not the basis to pass this judgment, my lord. This Honorable Court, after my lord taking to consideration of all the reports submitted before him, that record was called for the report of the RI, report of the Tahsildar, and the earlier order passed in 79 by the previous Tahsildar, that considering all the materials, my lord, this order was passed in favor of the petitioner, that the inquiry has already been made. He was in interrupted physical possession over that property since 1952 because he was used to pay rent to the ex-intermediary since 1952. Thereafter, my lord, Estate Abolition Act came under Section 3, the rent was assessed, but when it declined, my lord, to when you declare to recognize him as tenant and for acceptance of rent, thereafter, my lord.
What is amazing is without reading this judgment, you're able to argue completely contrary to the judgment. You're not even aware of the judgment.
No. Aware of the judgment means, my lord, he has not cited that, because 93 Supreme Court, that is already relied upon, that Vasanthi Sahu case, relying upon that judgment, my lord, this judgment was passed.
All right. You see, so we pass the detailed order. The review petition is allowed. And the writ petition is restored to file. The writ petition is dismissed. In view of the dismissal of the writ petition, the contempt petition is dismissed. All right. The detailed order will be.
Special vehicle list item number 30.
May I please, Your Lordship?
Yes.
And in this case, on dated 10th of January 2013, interim order was passed, and in similar matters, Your Lordship already passed order granting liberty to the petitioner to move the authority, and he will pass the reasoned order.
Counsel, the petitioner seek leave to withdraw the present petition with liberty to approach the authority in accordance with law. Disposed of as withdrawn, with liberty is paid for.
Special vehicle list item 31.
I'm appearing for BMC in this.
Item 31.
No instruction, let's say. 31.
No instructions.
Item 32.
32 minor infructuous.
Infructuous disposed. Both matters.
Special vehicle list item note 33.
None appears to be.
Special vehicle list item 34.
I'm appearing for the opposite party, Chillers.
None appears to be.
Special vehicle list item 35.
35 minutes during pendency of appeal, I have approached your lordships. Now, in the meantime, appeal has already been disposed of.
Or concept petitioner states that writ petition be rendered infructuous is disposed of.
Special vehicle list item 36.
None appears to be opposition.
Item number 37.
May I be the lordship? So in this case, whatever the petitioner has challenged, if dropping order passed the opposite by 2-1, I had answer 4, pays 26 million. Though the petitioner, as an appellant, prepared appeal under section 9, he with government notification, prepared the opposite by 2-1, but the opposite by the erroneously held that, kindly say a moment, pays 21. The Ranjan Suna, that is the order of 11/1/13. Ranjan Sir filed appeal under section 9 of the Act, challenging the order passed with Tahsildar Contaminant in Bevandas case 24/1 on 28/12/1. Peru the petition and found that the appeal referred is against the order of Chowdhury case and under Orissa Village Police Act as per section 8 of the Police Action Act. appeal against the order of Tahsil lies before the collector, Balangir. Hence, the case has no power. When the court has no power to deal the case is dropped. My submission, Lordship, is there. For a moment, Lordship preferred a memorandum of appeal, page 27. Actually, the present petition was the appellant prepared appeal under section 9 due to the government notification under as against the Bebandas case, not as in Chowdhury case, Miller. But without admit the case, the sub-collector dropped the proceeding, saying that you have challenged the order of the Chowdhury case. My submission is that no opportunity given to the present council, present petitioner, and the case has not heard by the council. But without no opposition behind and back of the appellant, the case is dropped. Aaron Holder Chowdhury case has a challenge. But actually, the appellant has a challenge on Bebandas case, not Chowdhury case.
Where is the impugned order?
Annexure 4. Page 26. Page 26, Miller. 11-1 to 13.
You're saying yours is a Bebandas case.
Bebandas. Actually, Bebandas case preferred, not Chowdhury case preferred. If the petition could have filed by Chowdhury case, that will be for the collector, not the sub-collector. But actually, the present petition being aggravated or bordered by the Bebandas case, preferred appeal before the sub-collector.
Is that right, sir? For Bebandas, it has to go to the sub-collector only.
Yes, if your lordship will remand it to the sub-collector, but then your lordship may kindly record the statement of the council that he is not challenging the order passed in Chowkidar case number so and so under the OBI Act.
I have the
because that has got nexus with both the cases.
I will not challenge.
No, in fact, first paragraph itself, he notices.
Yes, that is there.
In the impugned order dated 11 January 2013 of the sub-collector Titlagar, it is noticed in the first paragraph itself that the challenge is to an order passed with the Tahsildar Kantabanji in Bebandas, the case number 24 of 2001.
Or 28.
And yet, the appeal was dismissed on the ground that it is preferred against an order of a single quotes Chowkidari case. Number 505/65-66. Constantly, the petitioner states that the appeal was not against the aforementioned order in the Chowkidari case, but only against the order passed with the Tahsildar Kantabanji in Bebandas case. In view of the categorical assertion made by the counsel the petitioner, the impugned order dated 11 January 2013 of the sub-collector is hereby set aside. And this is what miscellaneous appeal number?
Appeal number
1 by 113.
And miscellaneous appeal case number 1 of 2013 is restored to the file of sub-collector Titlagar to be proceeded with in accordance with law. Since the appeal is in fact against an order passed by the Tahsildar in a Bebandas case. The sub-collector will now proceed to dispose of the appeal within a period of the appeal will be listed before the sub-collector on 19th September 2022, on which date the present petitioner will appear along with the downloaded copy of this order. The sub-collector is requested to dispose of the appeal within a period of 4 months thereafter. The petition is disposed of in the above terms.
Special Wikilist item 38.
It could be disposed infructuous.
Infructuous disposed of.
Infructuous.
No instruction.
No
Same.
Special Wikilist item 39.
There's no instruction.
No instructions.
Liberty may be granted. If
No.
Item 40.
I am permitted to withdraw my
Counsel petition seeks leave to withdraw this petition, dismisses withdrawal.
Item 41.
The petitioner here is a landowner having agricultural land. His sought grievance is that the government, without initiating any process for land acquisition, is trying to put up a road in the middle of the petitioner's property. Lord, if the Lordship would kindly see, they have filed a counter. In fact, in the counter, the state has taken a positive plea that they have not acquired the property and the land is coming within that alignment. That is what their counter is. Kindly see their counter
But they've not acquired means that's the end of the matter.
But they are saying that again, the alignment is over the petitioner's land. That's there.
So they'll have to take steps to acquire it.
Yes, my lord. They are saying both the things. Therefore, that is their counter. Kindly see page 3 of their counter. In view of this counter, then in the middle portion, are your lordships looking at the counter? Page 3 in the middle portion. Land corresponding to 356 by plot number 356, 358 of Pohanga required for construction of road, but they are not acquired.
But next paragraph they say as the land stated was not been acquired.
That's what they're saying.
All
but
right.
then they say that it is required.
In reply to the present petition, a counter affidavit has been filed by the assistant engineer Panikoli, R&B subdivision, in which inter alia it is stated in para 6 that as under, just come to the bottom of page 2, the paragraph starts, there were private land coming on the approved alignment of the road up to the end of page 3 paragraph. In view of the above statement made in the counter affidavit, no further directions are called for as far as the present petition is concerned. In the event that in future any attempt is made by the state to resume to undertake any construction which falls on any land of the petitioner, it will be open to the petitioners to seek appropriate remedies in accordance with it. The petition is disposed of.
It shall be open to raise all the points, my lord.
Yes, obviously.
Because they are trying to have a culvert over that land. If a culvert is there, both side land will be greatly affected.
Right.
Both sides. They will be washed away. The entire crop will be washed away.
All right.
So Lakshmi may kindly observe that if such a grievance is raised, they will consider it.
That's right. We are permitted to take all remedies.
Right.
Item 42.
May I please, Your Lordship? Item 42. The petitioner here, challenges on the virus, the virus of the lease amendment, that is Annex 6, as well as the demand notice. The crux of the matter is that, the petitioner is a company who was set up and was drawing water from natural source. And that has been, now they are charging water cess for taking water from the natural resource.
So there's no now. The now is 2013. Now is 22. Actually, the real now is 2022. And there has been no stay in all these 9 years.
No,
in the last 9 years, there has been no stay.
No, my lord.
So this one status quo got changed in 2013. That has continued.
They have been raising bills. As per my instruction, they have been raising bills. We have been paying on the basis of consumption, not on basis of allocation. Because that is
on your own. No stay order, nothing.
But my lord, may I kindly place the judgment which my lord recently passed.
Right.
Similar matters. Challenging the virus, my lord.
All right.
I have placed, my lord.
You make a representation. That's what.
Because all these matters, my lord.
You want to be covered by the same order.
My lord, let us actually represent, because our case can be considered by the state committee, my lord. That has been found.
All right. Counsel, the petitioners says the petition be satisfied if an order similar to the order dated 28 June 2022 in OJC number 10916 of 1997, bracket Tata Iron Steel Company Limited versus State of Orissa, unquote, is passed in the present case as well. Consequently, the present petition is disposed of with the following directions. Repeat that. 3, 1, 2, and
Special vehicle list item 43.
43 withdraw. Permitted to withdraw.
The memo is taken on record. Dismissed as withdraw. Right.
Special vehicle list item 44.
No instruction.
No instructions disposed.
Special vehicle list item 45.
In this case, my lord, I am appealing on behalf of the petitioner in WPC number 12,609 minor on VC minor.
Yes.
My lord, I am for the petitioner in WPC number 12,609 of 2013 minor.
Yes.
Batch cases, but I am for the petitioner in WPC 12,609 minor.
All right.
My lord, all the four items, four petitions are appealable order under section 7 of the OGLS Act. I will file appeal. The order passed under section 3 and 3B of the OGLS Act.
Counsel, the petitioner states that he'll prefer the remedy of appeals under the OGLS Act and accordingly seeks leave to withdraw the present petitions. Disposed of, withdrawn with liberty is paid for.
All the four petitions.
Yes.
My lord, your lordship may leave the
Except-
report, man.
Yes,
Except
yes, same.
12,609.
Yes.
Well, in 2,609 minor, your lordship may dispose of giving liberty to approach.
We have done that, sir.
Appeal, yes, that is.
Special weekly list item 46.
46, Your Lordship, I pray twice time to file reasoned affidavit. Last occasion, the counter have been solved, Your Lordship.
It's all right. What is the matter about it, sir?
OGLS ର appeal file କରିବା ବି ପଡିବ। ହଁ? ଏଠି ଫେର ଏଥର ମୂଳ ଛାଡ଼ିବେ।
Minus 46. 46, Your Lordship, I pray twice time to file reasoned, Your Lordship.
Tell us what the matter is about, sir.
A matter, Your Lordship, the lease allotted to the ex-Jawan, Your Lordship, the present petitioner is the ex-Jawan. The lease was granted in the year of 1976, Your Lordship. Till date, they have not allotted the land, Your Lordship. That is the issue, Your
There's no
Lordship.
Jawan lease now, sir.
My Lord,
That is no more implementable because the rule has been changed. No Jawan lease is going to be granted to anybody. In
Yes.
view of that, we pay lump sum amount.
so what my Lord senior stating, Your Lordship, at the time of issuance of lease, Your Lordship, the rule was there, Your Lordship. In 76, Your Lordship.
It's all right, sir.
And the counter filed only on 18/5, Your Lordship, on last date.
It's all right, sir. Nothing much. There's no Jawan lease these days. The whole policy has changed.
I have to examine the counter and file to
We don't, sir.
revision, Your
We
Lordship.
are aware of all these matters. We have handled hundreds of such
Hundreds of cases have been disposed of on that
Yes.
new notification.
Yes. You see, the prayer in the present petition is for grant of allotment of land in favor of the petitioner. For directions to opposite parties 3 and 4 to allot land in favor of the petitioner based on a patta issued in lease case number 1276 of 1976 under section 6 of the Orissa Land Reforms Act. Paragraph. The whole claim is based on the fact that the petitioner is entitled to allotment on leasehold basis on the basis in the capacity of Jawan lease. Full stop. During the pendency of the present writ petition, the entire policy of the state government has undergone a change. The system of allotting Jawan leases has been withdrawn, and only monetary compensation is contemplated under the present policy of the state government. Consequently, the prayers in the present writ petition cannot be granted. It will nevertheless be open to the petitioner to approach the state for appropriate reliefs under the present policy devised by the government. The petition is disposed of in the above terms.
Special weekly list item number 47.
Particularly in view of the recent development, I have filed affidavit. For person to lordship, kindly say affidavit.
I have not been
Annex-
served with a copy, my lord. Copy of affidavit has not been served.
Lords, annex page 21, your lords, annex 21 page 11, your lordship kindly see. Government wanted to for regularization of land, source land in favor of schools and colleges.
that is available page 11 and 12. And we have applied in page 14, Lord. So that has been accepted. And a similar matter, Lordship, kindly see page 17 of your Lordship's order.
Same order. You see, Council Petitioner states that he will make a representation to the Commissioner cum Secretary of the Government General Administration Department, Orissa, for allotment of alternative land, not later than 19th September 2022. In event such a representation is filed by the petitioner, opposite party number 1 shall examine it and pass a reasoned order thereon, not later than 1st December 2022. Till such time, the interim order passed by this court. What's the date here? Is there any interim order, sir?
Yes, my lords. Interim order was there.
All right. 18 July 2013 will continue. If agreed with the decision taken on the representation, it will be open to the petitioners to seek appropriate remedies in accordance with law. The writ petition is disposed of.
I am appearing for OP number 4. My name may break.
All right.
Special Vehicle List item 48.
May I please, Lord? Here I have challenged the demand notice under NSS 6 on the ground that for the entire year I was not allowed to lift my quota as because my petition for shifting of the soap was pending with the authority.
Sir, all these policies have changed now.
My lord.
The entire liquor policy has changed. You see, due to subsequent developments, the entire petition has become infructuous and disposed of as such.
Special Vehicle List item 49.
49, I am for the department.
No, the memo is taken on record. Dismiss is not pressed.
Special Vehicle List item 50.
None appears dismiss not pressed.
Special Vehicle List item number 51.
Permitted to withdraw, my lord.
Permitted to withdraw. Dismiss is withdrawn.
Special Vehicle List item 52.
Item 52, my lords. Here I have filed the present writ application, my lords, because I was given a work order from opposite party number 3. As per the terms of the work order, I delivered certain materials to the opposite party number 3. And my lords, when I raised the check for payment of the dues, my lords, I found out that the bank account of the opposite party number 3 has been frozen by the DG Crime Branch due to some allegations of chit fund scheme, my lords. My lords, now my only prayer before the court is that since a long time my rightful dues have been pending before the with the opposite party 3, my lords, I am unable to entitle myself with the said amount because of this freezing of the bank account of the petitioner, my lords. Opposite party number 3, my lords.
I think he's not aware, my lord, that in 2013, 24/9/2013, pursuant to proceedings in the court below, there was a letter that was issued to unfreeze the accounts. 17/8/2013,
my lord,
the branch manager HDFC Bank Bhubaneswar was intimated to defreeze the account of that particular. So defreezing is already happened, my lord. All right. Counsel, Mr. Nayak, counsel appearing for
the state.
HDFC. No, my lord, the state. Appearing for the state refers to the communication from the HDFC Bank.
From the economic offences wing, man.
From the economic offences wing to the HDFC Bank, defreezing the petitioner's account. In that matter, no further directions are issued. The petition is disposed of.
My lords, may kindly give me liberty to approach the appropriate authorities and state all grounds so that the representation can be disposed of, my lords.
Then you simply withdraw it. Petitioner seeks to withdraw the present petition with liberty to approach the state with a representation for appropriate directions. This was just withdrawn with liberty as straightforward.
My lords.
Special Vehicle List item 53.
53, my lord, annexure 16, where a demand has been raised towards, my lord, transport fee or ENA imported from outside the state, my lord. Lordships have on 1st August, my lord, disposed of the matter, but I have corrected the annexure and date.
Same order.
Special week list item 54.
May I please, Your Lords? My Lords, I have challenged the order passed by the additional commissioner of sales tax, who has rejected my revision petition and holding that battery, a tubular battery supplied along with UPS will be charged tax at the rate of 13.5% on residuary entry instead of 5% as per the entry 69G of the VAT Act. And therefore,
Let's see the entry, sir. Let's see the entry. 69G.
G. I have waited, my lord.
Amount here is 55,000.
But at page 5.
For such a insignificant amount, you want a judgment. The amount is 55,000.
My lord, this is a very important issue. It is similar.
It is important, sir.
On this similar
Every
line,
issue is important.
On this similar line, the Honorable Punjab and
This is
Haryana
overt
High-
act.
Haryana High Court has passed judgment holding that cell phone along with charger will be taxed under the rate applicable
UPS
to
and
cell
their
phone.
parts. This is uninterrupted power supply and their parts.
Yes.
What are you selling, sir?
I say, since the material was supplied,
sorry,
material, that is the battery, along with UPS under a single package, that is under Annexure 2.1.
No, is the battery a part of the UPS?
Yes, because without the battery, UPS cannot function. Because battery supply uninterrupted power to the computer system. When there is a
itself-
breakdown, the UPS draws power from the battery and convert it to SC. One alternative.
But without the battery, there will be no UPS at all.
No UPS. At all. That is the
itself is a battery.
No. It's not that one battery plus battery, sir. That's what he's also saying.
The entire computer system will be paralyzed.
Yes.
So it is similar judgment. Punjab and Haryana High Court, when there is a single package and the material is supplied under a single package and tax has been charged 5%.
Right. Tell us.
Then
Show us.
division bench, the cell phone and the charger was taxed at a cell phone. Nokia, India.
Composite package. Yes, Mr. Mishra. Yes, Mr. Mishra.
Your Lordship, at page 65, Your Lordship is absolutely right. At page 64, the operative portion
Yes.
is at page 65.
Yes.
Your Lordship, 5 lines below on physical verification. Your Lordship got it at page 65.
Yes.
On physical verification, the vigilance officials found an extra UPS system having no invoice was available in the vehicle. As the dealer petitioner charged VAT 5% in place of VAT 13.5% on excise battery, as unspecified good learning DCST, so and so has levied the penalty. In response to notice, the authorized representative of the dealer company vigilance were produced purchase invoices, computerized and so and so, being confronted to the by the learned about less payment 5% sale number. AH Excite tabular charged batteries instead of 13, but the air contained that sold UPS, which is chargeable to 5%. And batteries are sold as package as essential part of the UPS. For the charge of that 13.5% invoice issued in favor of Muthoot Fincorp Limited, ASCA branch on sale of 2 pieces of so and so Southern PP dry battery. The air contained that they have sold 3 system with DC. So in different uses, this has been sold on different purposes, Your Lordship. So for that reason only, it has been stated that UPS, the battery cannot only be used for the battery UPS system.
What else will it be used for?
Battery.
If it's a package, what will it be? Like it's like torchlight and batteries, right?
Your Lordship.
Suppose sometimes you sell it separately, sometimes you sell it as part.
What has been sold, the battery, what has been sold for the UPS purpose,
yes,
that can only be taxed at the rate of 5% as Your Lordship held.
Correct.
Your Lordship.
That is under Annex 2.
All right. The revision petition is allowed. We'll pass the detailed order.
Your Lordship.
Special weekly list item 55.
None appears to assist, not possible.
Special weekly list item 56.
Item 56, my lords. Case is very simple, my lords. Fact remains, my lords. I purchased some portion of the land. East Coast Railway, my lords, laying that Balangir rail line. I found in field that my portion of the land, my lords, so they are using it for the purpose of laying one road, that railway line. I requested the land acquisition officer. He says, no, this is not their plot. And we are not encroaching your plot. We requested Tahsildar. Tahsildar said that I don't have map to supply you. Only thing is that, my lords, suppose my plot is not, my lords, included in this, I am happy, my lords. Suppose this plot is on acquisition, then I will be entitled to the compensation only.
Correct.
What I pray, my lords, only a joint demarcation in presence of the opposite party number 2 land acquisition officer and Tahsildar and myself, so that it will be clear. And thereafter, if my land goes, I will claim compensation. If my land doesn't go, then I will be happy, my lords. I will be enjoying my land. This is what is my prayer, my lords.
No, but
my lord, if the land is not covered in the notification, where is the cause of action to claim compensation or any apprehension? There has to be a notification.
No, there has
Your
to be a
plot
notification.
has to be included.
That notification. Sometimes what is that? The Khurda Balangi road, they are going in a very interior part.
Only recently, I remember reading a huge notification, land acquisition notification for the same railway road.
This is not in the land acquisition notification, but they are using it.
Then
that
it is what I dispute. Then it is a civil dispute. You can file a civil suit for injunction.
But here in this case, my prayer is very simple. Only thing is that for a demarcation. If it is
demarcation, you can apply to the Tahsildar for demarcation.
I have applied for the Tahsildar. I will apply. Again, I apply to Tahsildar for a joint demarcation. Miles may permit that. I will do that.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to approach the Tahsildar in question for demarcation of this land. If such application is filed not later than 12th September 2020 or 19th September 2022, Tahsildar will proceed in accordance with law and complete the demarcation exercise within a period of 2 months thereafter. The court clarifies it has not expressed any view in the matter. No other relief is sought for at this stage. The petition is disposed of.
Your Lordship, beg your pardon, Lordship. For opposite partner 1 and 2, I am appearing.
All right.
Special weekly list item 57.
To mention item of which could be read petition, not revision petition.
All right.
Special weekly list item 57.
57. 9. 20390.
And pleasure, Lords.
Aravind Daman.
The land acquisition notification is under challenge. The ground that here is as per so far the counter reveals the ROR of issued in 1930 has been relied upon in a land acquisition of 2007.
So there's no stay in all these last.
Stay in the connected repeats on WPC 10436 of 2011. Origin of same notification.
What? Where is the penalty petition? It's not there on the list.
That is not.
So there's no stay. As far as the present petition is concerned, there is no stay.
No stay. But here is the petitioner's land has been acquired.
Where is the award?
They have said the award, they are not including this. You will also may kindly have a glance to their counter, but they have stated. Annexure 1, Annexure A by 5, the ROR itself published in 1930. So land acquisition proceeding initiated 2007. After 77 years, Your Lordship, there are so many transactions has been done. So the petitioner's land, though acquired, that I have avoided in para 10, that my sale deed as well as the mutation numbers.
My lord, basically this is a dispute between rival claimants to get the, in that event, section 30 is the reference has to be made. Civil court has to say that whether you are entitled to get or somebody else is entitled to get.
Correct.
Now the writ court cannot interfere with that. That is my responsibility.
There is no rival claim at all. My sale deed is there, mutation case I have mentioned.
You did not file even a 5A objection, sir. Where's the question, therefore?
Rejoinder I have filed.
No, your 5A objection you never filed.
Because that was not within the knowledge. Because
that is not the ground, sir.
That
is not the ground.
Public notice.
Public notice to 1930 ROR they have relied upon.
Yes.
How can the 1930 ROR relied upon a proceeding of 2007?
Yes.
And itself their counter have some points.
What is the date of the award?
Date they have not mentioned when the award was passed, against whom the award was paid, how many persons, that is not mentioned in their counter. In para 7, if I pay 7, they are for due to the non-cooperation of the co-shares, the award has not been framed. The payment of compensation petitions shall be made after framing of award. So award has not been framed. Their counter.
No, this is a counter filed long ago, sir, 2014.
Yes.
By now, award would have been passed.
This is 8 years back. There was the status was award has not passed, and what he is saying, there was no rival claimant. We given the award to the recorded owner of 1930, and he is saying that he is a subsequent person who has acquired the land. So these are the disputes which ought to be agitated before the civil court.
Right.
If the award was not para 17, they say.
After passing of the award, you will do that.
How the lease execute? If award not passed, how the lease
execute? How can the award not be passed, sir? It's a 2014 matter.
It is now 22. What is the current status that?
Let them to obtain the current status. The lease has been executed in the meantime. Para 17, they are saying.
There's no rejoinder.
The rejoinder in fine 2016 or not in record. So if another copy I may use to file. 22 February 2016.
No.
Showing that copy I may file again.
It is pointed out in the counter affidavit that the present petitioners, claiming to be subsequent purchasers of the land from the original landowners, did not even file an objection to Section 5 capital A of the Land Acquisition Act 1894 to the notification of the Section 4 bracket 1 of the Land Acquisition of the LA Act. It is further pointed out that the declaration to Section 6 bracket 1 of the LA Act was issued way back on 22nd November 2008 itself. So from 2008 to 2014, how can an award not be passed?
That I also believe that award must, because after 6-1, then award
has to be passed. Within a year or two, there has to be passed. The court is of the view that the award must have been passed quite some time ago. Although it has not been mentioned as such in the counter affidavit. If the petitioner is agreed by payment of inadequate compensation or non-payment of compensation, it will be open to the petitioner within the framework of the LA Act, which is now repealed. Actually, now the LA Act is gone.
But it is in the old Act,
right.
This particular time.
Read with the new 2013 Act to seek appropriate remedies in accordance with law.
No, my lord, old Act. This is covered in old Act.
Right. To seek appropriate remedies in accordance with law.
Item number 58.
Problem.
Please, Your Lordship. Annexure 5 is included in this writ petition. Annexure 5 is impugned in this writ petition. Your Lordship may kindly see, it is an order passed under Section 33C(2) of the Industrial Dispute Act.
The initial order was passed under Annexure 1. Order means the award was passed under Annexure 1. The Lordship may kindly see the last page of the Annexure 1.
Has the opposite party been served?
No, it is not finished.
Opposite party number 2 has been served. What's the award do, sir? What is
Annexure 1, Your Lordship may kindly see the award.
20,000.
Para 8, my lord. Here, my lord, the workman alleged that he had been illegally terminated. But we say, according to the employer's case, my lord, that he abandoned the services and did not come forward. However, the court, my lord, hold that no, his services were terminated. And in para 8, your lordship may kindly see Annexure 1 at page 15. Regarding the back wages, it is settled principle of law that the relief of reinstatement with full back wages would not be granted automatically only because it would be lawful to do so. For the said purpose, several factors are required to be taken into consideration.
20,000 alone has been awarded, sir. Nothing at all.
This is the original award, my lord. And they quantified, the learned presiding officer quantified it only to 20,000 with interest at the rate of 9% per annum.
Yes.
Now, my lord, on section 33(2) of the Industrial Dispute Act, he filed an application, and there, my lord, the back wages were determined once again, my lord, which was not within the purview of the section 33(2), my lord. That was the case, my case here. And even no finding was recorded. Lord, may kindly see 33.
No, I'm not able to. Page 15 is the original award.
Original award, my lord. That is Annexure 1, your lordship.
Yeah, once he's reinstated, the original award did not say back wages. No stay here. You must have implemented. Is there a stay of the impugn award?
No, yes, my lord.
When was it stayed?
My lord, internal page 7, my lord. Annexure 1 at page 15, internal page 7.
Sir, you're not following the question. Was the award stayed by this court?
No.
So you must have paid the amount by now.
But that petition has also been dismissed. So this award stands. This award stands. We are entitled to pay 20,000 rupees with interest at the rate of.
Even the 33C2 order has not been stayed by the court.
No, my lord, it has not been stayed.
Have you paid the amount?
That instruction, my lord.
What do you mean? There's no stay at all granted.
My lord, according to us, my lord, under section 33(2), the learned labor court had no jurisdiction to adjudicate, my lord. Appraise at what is the quantum of the amount to be paid.
No, quantum alone he can adjudicate, sir. 33C2 is to quantify the amount due. The whole purpose of 33C2 is that only.
33C2 is only an execution, my lord.
Correct. So the award is already in his favor of reinstatement plus 20,000. So he goes for 33C2 to find out the exact amount due to him.
Not your lordship may call it on some other day.
Why? I think there's nothing in this matter. The challenge with the management in the petition is to an order dated 13 June 2013 passed by the Labour Court, Bhubaneswar, in ID Miss Case number 34 of 2012. That is in an application filed by the opposite party, number 2 workman, under section 33, capital C, bracket 2 of the Industrial Disputes Act 1947, bracket ID Act.
In February, my lord, the Supreme Court said that this cannot be.
The above order of the Labour Court was
adjudicated once again.
When award dated 23rd March 2010, whereby after finding the termination of the services of the opposite party number 2 to be illegal, the Labour Court directed reinstatement together with a lump sum amount of rupees 20,000 as compensation, open quotation, in lieu of back wages. Yeah, 23rd September. All right.
That my lord, we are
However, while
entitled to
computing
pay
the award,
interest at
computing
the
the
rate of
amount
9%
in terms
per
of
annum.
13 June, in its order, impugned order date 13 June 2013, the Labor Code appears to have, in fact, quantified the amount by calculating back wages, which is not permissible since the amount of compensation of 20,000 was in lieu of back wages. Paragraph. Consequently, the impugned order of the Labor Court dated 13 June 2013 is modified by clarifying that it's modified, and the opposite party number 2 is held entitled to receive rupees 20,000 as compensation, together with interest as already directed by the Labor Court in its award dated 23rd September 2010. The petition is disposed of in the terms.
Special vehicle list item 59.
None appears to assist in opposition.
Your Lordship, appearance of Union of India.
No instruction in the
Yes.
Item 59, my lord, I am appearing for opposite pet number 2, my lord.
All right.
Your Lordship, for Union of India, opposite partner 1, Your Lordship.
All right.
Item 60.
None appears to assist.
Item 61.
None appears to assist in opposition.
Item number 62.
62 millets pursuant to Annexure 1 millets. There is some delay millets, but I have already made the payment millets. The challan I am just handing over millets. Pursuant to Annexure 1 millets, the opposite party number 1 directed the petitioner to deposit 1.75 lakhs millets. But there is some delay, but in the meantime, I have already deposited the amount millets.
No. Are you still pressing for the reliefs in the writ petition?
So I'm challenging Annexure 1 millets to the impugned order millets.
Yes.
Page 22 millets says directed to deposit 1.75 lakhs millets during certain period millets by some date. But there is some delay millets, but in the meantime, I have already deposited.
Council petitioner states that he's already deposited the amount of rupees 1.75 lakhs as directed in the impugned order. However, with some delay, will stop the delay in making the payment be condoned. No, is condoning the delay in making such payment, the petition is disposed of.
Special vehicle list item 63.
63, my lords, no instructions. I may be given liberty to
No, sir.
file afresh if any cause of action.
Council petitioner says he has no instruction. Dismiss for non-prosecution. Right.
Special vehicle list item 64.
None appears to assist in non-prosecution.
Item 65.
May I please your lordship, my lord. My response submission of due diligence, my lord. Here the Annexure 1 being impugned, passed by the learned ADM, Additional District Magistrate Puri, my lord, had Annexure 1 running space 10 is hereby challenged. The case is guided by Orissa Government Land Settlement Act 1962. With due diligence, I humbly submitted that initially there was a revenue miscase instituted against the mother of the petitioner. And that revenue miscase, my lord, as per the order passed by the ADM had Annexure 1, that was disposed of on 23 September 82, my lord. When the revenue miscase was disposed by the then Tahsildar concerned, my lord, in favor of the mother of the petitioner on 23 September 82, my lord, after last section of the long years, more than 13 years, my lord, this revision is registered, which is also not permissible in the eyes of law. In this junction, my lord, I humbly submit, I am relying two decisions, my lord, of her own Odisha High Court, my lord, reported, my lord, the 2006 volume 1, OL Act, page 184, my lord. The class item is like this. I humbly submit, my lord, Odisha Government Land Settlement Act 1962, Section 7A, so much the revision, no proceeding under the section shall be instituted after expiry of the 13 years from the date of the order. In the present case, revision initiated after exceeded said period of limitation, revision case is wholly without jurisdiction. This present revision case, my lord, admittedly was while Annexure 1 was instituted in the, my lord, that is 2001. Please make a glance, my lord. OGLS revision case bearing number 48 of 2001 was registered in the year 2001, my lord. And so far the order of the Tahsildar concern that was came into light, my lord, that is 23 September 82, my lord. So after a prolonged period, though the revision case was instituted, that is bad in law and not permission the law, accordingly, the Annex 1 should be struck down. It is my first count. So far my submission is
So no replies were filed.
No reply has not been filed, but recently, Your Lordship, in case of Asahans versus State of Orissa, Your Lordship has held that fraud has been where fraud is there, and following the decision of Brindavan Sarma.
No, but
that
you don't even file a reply. How do we say all that?
Oh,
Some replies to be filed. Also, the state assures the court that reply will be filed within 4 weeks, rejoinder for the next date. Interim order is there.
No.
All right. List on 16 November.
Special week list item 66.
None appears. No problem.
Item 67.
None appears. This is not possible.
Special week list item 68.
Item 68 permitted to with liberty to approach before appropriate forum.
Counsel petitioner seeks leave to withdraw the present petition with liberty to approach the appropriate forum in accordance with law. Disposed of is withdrawn with liberty is paid for.
Item 69.
None appears. This is not possible.
Item number 70.
Your Lordship, I am on behalf of Mr. Bigan Kumar Sharma. Order has been complied.
Order has been complied. The compliance
Counsel for the
affidavit is flag
petitioner,
Y.
counsel for the opposite parties state that the order has been complied with. Petition is disposed of.
Please, Your Lordship.
Special week list item for orders item number 71.
Item 17, I have no instruction, Your Lordship.
No instructions disposed of.
Item 72.
Item 72, my lord, Mr. Zenna is in ICU, my lord. Let it come after 2 weeks, my lord.
We have already copy served, my lord. Only on substitution and delay condonation and setting up website. I am for the LRS.
Mr. GB Jana is ill.
His division is in ICU, my lord.
There, opposite party workman is dead, my lord.
Oh, he is also dead.
Counsel for the
petitioner, my lord.
Petitioner is
petitioner
one
stated to
case,
be unwell.
another
All right.
for the management.
Counsel the petitioner stated to be unwell. List on
Pardon, my lord.
18th October.
Date holds it on
18th October.
18th October.
Special week list item 73.
Obliged.
Item 73.
None appears. This is not possible.
Item number 74.
All these is in the IA. None appears. This is not possible.
Special week list item 75.
May I please, Your Lordship? In this content, I filed an IA for recalling the order, my lords. And by my lords, in this contempt, the opposite party management had deposited a check of rupees 9 lakhs some odd on 22/9/2016. Thereafter, in read appeal, they obtained a stay, and therefore the petition could never get that check. Recently, on 9/5/2022, my lords, Your Lordship dismissed all the three read appeals, and simultaneously, this contempt was also disposed of in view of the dismissal of the read appeal. My lords, my humble submission, my lords, since they had deposited a check, let them revalidate it and hand over the petition. Petition has
Yes,
been.
who's for the other side? Notice is not gone in this.
My lords.
Okay, I in 194 of 2022 notice, she accepts notice, complete
State
settlement.
is not a party, my lords. Management, New India Assurance Company.
All right.
They have
Let me
to
just
issue
see
notice.
notice returnable. 2nd November.
Special weekly list item 76.
Item 76, my lords, the constitutional validity of section 12 of the Orissa value-added tax is under question, my lords. No counter rate has been filed, my lord, despite the service of the copies. In the meantime, my lords, I have filed one IA. My lords, a minor amendment is required instead of section 12. It has been typed, my lords, section 12 IIA. That IIA has to be deleted, only 12.
All right. The correction be carried out as prayed for. Right.
Obliged.
Your Lordship, Your Lordship may fix a date of hearing. Your Lordship, I may be permitted to file counter. Your Lordship.
No, which please? Which is this item?
That was 76.
Oh, 76. No, he's arguing something. I think you are arguing something else.
No, Your Lordship.
This error which is saying 12 II is in which matter?
Your Lordship, he has challenged the virus of section 12 of the Orissa value-added tax.
He wants the tray to be read as 12 II, is it? He has challenged only 12 IIA. It should be 12 II.
It should be 12, my lords.
Now, what do you want to challenge at this point, sir? The VAT Act is now over.
No, it is not continuing, sir. My demand is in the VAT Act, my lords. Lots of appeals are pending, my lords.
Your Lordship, after assessment order, this the constitutional validity has been challenged under section 12, Your Lordship.
You have to file a reply now.
Your Lordship.
Yes, no reply has been filed, my lords.
Reply be filed within 8 weeks.
And the corrections accordingly I will make.
At the outset, petitioner points out that he may be permitted to amend the prayer clause to indicate that the challenge is section 12 of the OVAT Act and not 12 bracket Roman small 2. He's permitted to do so. And then you say notice. Notice has already been issued, correct? Has notice already been issued? So why don't you reserve these grounds after you succeed in the appeal? This annexure 1 and 2 are assessment orders.
The department cannot hear the matter constitutional validity of the section 12. So far as my petition is concerned, the validity of section 12 is concerned.
I know, sir. You're challenging it on some grounds, correct?
Yes.
Because of that challenge, you're also challenging the assessment orders, correct?
Yes, ma'am.
So against the assessment order, you have the remedy of an appeal.
Correct, my lords.
So if you succeed in the appeal, all this becomes academic. Your challenge to section 12.
No, because the crux of the minors reopening of the assessment order is minors section 12 pertaining to the receipt of a good state minors, which is ultra-virus to section minors entry 54 of list minors. That is our crux.
It is audit assessment. It is audit assessment under section 42.
Once assessment is done, thereafter the audit report has come, minors, based upon section 12 minors, which says minors, tax on receipt of goods in the state minors, which is not authorized under the entry 54 minors. That is our main question involved in this discussion, sir. Entry 54, sir, only speaks of sale and purchase. The field is sale and purchase. Here the says receipt of a goods is taxable. Therefore, in that event, my lords, in case of a branch transfer, it is also received under the Central Sale Tax Act. So that is a crux, my lord.
No. Branch transfer is anyway neither purchase nor sale. It's like a consignment sale, a transfer.
From the central government, my lords, as an incentive to export, my lords. They say that you have received since it is a taxable.
No. Is it to do with interpretation or virus?
It's the interpretation, my lords. No, it's a virus.
So why are you challenging the validity then?
No, virus, my lords. It's a virus, my lords, because entry 54 list 2, my lords, only permits the state legislature to legislate, my lord, only on sale and purchase. Not receipt of a good. They have said in section 12.
No, but that's an interpretation. So in a given case, whether as you contend, is it a branch transfer or a sale? or a purchase will be subject to what the factual situation reveals.
No, ma'am. So what has happened here, ma'am, in audit report, they say section 12 permits on receipt of a goods, my lord, tax can be imposed. That is what is violative of entry 54 of list 2 of the Constitution of India.
Now, who has said that the minute the goods are received?
Yes.
No, the authorities are saying.
Lordship, bigger lordship. Pardon?
No, the department is saying that even a branch transfer is.
Page 30, sir, may kindly have a look. Page 33 of the impugned order, my lord. It's my third paragraph. Section 12 provides, let's got it, my lord, page 33.
Yes.
Section 12 provides that a transaction of a receipt of any taxable goods by any dealer inside the state from any person other than a registered dealer in the circumstances in which no tax is paid under section 11 and the said goods are disposed of otherwise than by way of sale.
No, so basically what you're asking is section 12 to be read down.
Section 12 means the insertion of the word receipt is itself violative. There should be sale or purchase, my lords. That is unconstitutional. It's not permitted under entry 54 list 2 miles. And let's may kindly see the last bottom paragraph. In the course of the discussions made in the foregoing paragraph.
All right. You just say replies be filed within 8 weeks, rejoined up to the next date.
Much obliged, my
23rd November. Good afternoon, sir.
For orders item number 1.
That I am for the, that I was appearing for the Steel Authority of India.
Yes.
Not because after disposal, I have no instruction. If a petition has been.
No, but anyway, I don't know how this IA is maintainable at all.
Yes, my lord. After disposal, how this IA is.
How can a disposed of matter IA be filed like this? You say none appears for the applicant. In any event, such an application is not maintainable at all in a disposed of writ petition, which was filed by Steel Authority of India. This such an application by the opposite party in a disposed of writ petition filed at the instance of Steel Authority of India Limited.
I have not filed, my lord.
No. Writ petition is filed by you, sir.
Yes, my lord. I am filed.
Is not maintainable. Yeah, it's not maintainable at all. Consequently, the application is dismissed as being misconceived.
Okay.
Right.
Weekly list BLAPL 8763 of 2021.
May I please?
Yes.
I have given the instruction. Your Lordship can peruse it. That is a fake certificate.
Oh.
Last 3 lines, Your Lordship can peruse. On inquiry, it is ascertained that Dr. T.K. Raut was transferred from MKCG to Mayurvansh since last 4 months. Further, I verified at the medical authority MKCG, Barampur, about the
serious trouble, sir.
fake one.
It's very serious. I'm withdrawing my
Counsel for the petitioner seeks leave to withdraw the present application. Dismisses withdrawn. None appears.
Special weekly list item number 78.
None appears. Dismissal.
78 already, my lord, withdrawn, my lord. There is no instruction.
All right. No instructions.
Special weekly list item 79.
Item 17. May I please? My lord, the petitioner here has challenged the illegalities and irregularities committed by the office bearer of Orissa Olympic Association and Orissa Cricket Association, my lord. Your Lordship may kindly say Annexure 1.
These are of years 88 to 2000 and all that, sir.
My lord,
you're talking of the years 1988 and to 2000, irregular activities of those years.
My lord.
How can we keep reopening it now? Something that happened in 1980, between 88 and 2000, if you start in 2022, what will you get? You won't even get evidence.
That is still continuing, my lord. Till now,
Then
it is
you
also
file a fresh representation, go to the Lokayukt, whatever, sir.
obliged.
Counsel for the petitioner seeks leave to withdraw the present petition with liberty to make fresh representation to the concerned authorities, and after following up on such representation, to seek appropriate remedies in accordance with law.
Milords, I am representing opposite party number 9, that is BCCI. My
All right.
presence will be noted.
All right.
I am representing for opposite party number 8.
All right.
8 and 7.
All right.
Special weekly list item 80.
May I please your loss?
Yes.
Lord, this is a PL. Lord, in this case, I have challenged the illegal encroachment of government land by OP number 427. Lord, I have filed a short date chart, but from your lordship will get the things. And as for annexure 2, my lord, they have intimated the petitioner that the opposite part number 427 have encroached the government land and made some temporary and permanent construction. So we have made
there are 3 encroachment cases already instituted.
already there, my lord, already there, and one of the person has preferred a writ petition wherein some interim order has been passed.
So you can follow up on those proceedings, sir. Let's not have parallel proceedings.
No, my lord. In their counter, they have said that one person has preferred a writ petition.
That's right. No. So you can follow up. You can follow that.
He has not made me a party, my lord. Your lordship.
So you can file an IA to implead yourself, sir. You know the writ petition number.
Your lordship may kindly see, my lord. My lord, admittedly they have encroached the government land. And for last 5 years, we are running pillar to post for a road.
So pillar to post. Now you have 3 encroachment cases. You can follow up what's happening on those cases.
Your lordship knows that by making encroachment, this is a government land. By initiating encroachment cases, and this case will linger for years together. They have
you ask for specific. We permit you to expedite those cases. We can ask them to expedite those cases.
Well, how can I have no locus standi in those cases?
So we will ask them to expedite the cases, sir.
My lord, may I make a suggestion, my lord? Subject to your lordship's approval, my lord. My lord, if that writ petition which is pending before your lordship, can it be taken up along with this?
No, certainly not, sir.
Nothing will.
Don't forget the due process of law, please. In your anxiety, please don't abandon the due process of law.
Anxiety, my lord. Your lordship may kindly see there is no road in a rainy season.
Mr. Acharya.
Yes, ma'am.
I'm a bit surprised. All these writ petitions are being listed in its own turn. Nobody has mentioned any of these matters for even listing. So let's not go there. Let's not go there. Let us have the due process of law followed, and you can follow up on those matters. You say the contra affidavit filed by the opposite parties indicates that encroachment cases were registered against the
No. Eviction, they have said that eviction order has been passed.
Against one of them, sir.
Yes, sir. Against two
and
persons.
against, okay. And even orders have been passed against two of them. Arising out of those proceedings, a writ petition is also pending in this court.
And one appeal before the sub-collector.
And an appeal before the sub-collector. It will be open to the petitioner to follow up on the progress of those cases in accordance with law.
And
as far as the pending encroachment cases are concerned, a direction is issued to the opposite party state to expedite those cases and conclude them within a period of 6 months from today. No further directions are called for, the petitions disposed of.
Special weekly list item 81.
None appears dismissed and offers.
Item number 82.
May I please, madam?
May it please the court, I am appearing on behalf of Mr. Sambit Manti for the petitioner. My humble submission is that the petitioner has died.
Or counsel, the petitioner says the petitioner has died. The petition is dismissed as abated. Correct. Published.
May I please, my lord? My lord, item number 81.
Yes.
My lord, the present petitioners have filed the public grievance petitions to protect the communal land, such as First Motion, the Gochar land, and the opposite party number 5 and 6 are forcibly occupy their land. But the counter filed by the opposite party number 4, the partly of Hata number 3164 in favor of the school. That is partly. But in plot number 3166 has been partly buried and used by playground of the said school. But 3166, you measuring an area 1.35 decimal, that is Jalasaya 2. And let the, as per the counter made by the opposite party number 4, that is partly encroached. So that is hampered by the public. And the such school was declared as in the year of 2015 as ghost school, as annexure 4. That no such school was in the record of Board of Secondary Education. And Lord, running page 27. Running page 27 of the writ petition. That board declares that school as ghost.
That's it, sir. Anything else you want to say?
My lord, such type of school is not in the record of Board of Secondary Education.
Yeah, all right. The present petition has been filed by as a public interest litigation. praying for eviction of alleged encroachers on Gochar lands, Masana and ponds situated over plot numbers 3163, 3164, 2594, 3167, 3168 of Khata numbers 916 and 917 of Moza Siddhal in district Jagatsinghpur. Paragraph. This is the second round of litigation. Earlier, the petitioners had filed writ petition civil PIL number 3410 of 2015, which was disposed of by an order dated 27th March 2015, directing the Collector Jagatsinghpur to dispose of the petitioner's representation dated 18th August 2014. Paragraph. It is stated that the Collector Jagatsinghpur then took up the matter, called for the relevant case records from the Tahsildar, along with the report. Full stop. It was indicated in the report that the land has not been settled in favor of the single quotes Ma Ambika Sikshashrama, unquote, as alleged. Full stop. The field report also stated that there is no encroachment over the lands in question. Full stop. Since the petitioners failed to produce sufficient documents as to illegal encroachment, the collector, by speaking order, dropped the proceedings. Paragraph. The said counter affidavit was filed way back on 12th April 2017, and for over 5 years now, no rejoinder has been filed to contradict any of those averments. Paragraph. With the petitioners unable to produce any material to substantiate their allegation about encroachment, the court sees no reason to interfere. The petition is dismissed.
Special weekly list item number 83.
Permitted to withdraw your lordship.
Counsel, petitioner seeks leave to withdraw this petition. Dismisses withdrawal.
Special weekly list item number 84.
None appears dismissed and not prosecution.
Special weekly list item number 85.
Lordship, item number 85 through virtual mode, your lordship.
Yes.
Lordship, item number 85, I pray for an adjournment in this matter as the conducting counsel, Ms. Mini Misra, has met with an accident today morning.
What's the matter about, sir? Tell us.
Sir, Lordship, I don't have the file with me. That file is with the conducting counsel, Ms. Misra.
Counsel for the petitioner is in some personal difficulty today. List on 9th November.
Special weekly list item 86.
None appears dismissed, not prosecution.
Special weekly list item 87.
My lord, the matter has already been infructuous, my lord.
Infructuous, dismissed.
Special weekly list passed over matter item number 18.
May I please, your lord?
Yes, please.
My lord, the petitioner has challenged the sale notice, my lord, sale certificate. Your lordship, this honorable court directed by the order dated 5/9/2017 to my learned senior appearing for bank to take instruction whether the petitioner has deposited rupees 17 lakhs by the order dated 12/1/2012 and rupees 5 lakhs pursuant to direction of this honorable court on 30th March 2012, my lord.
Are matters pending in the DRT?
Yes.
No, my lord. DRT matter
has been disposed of, and OA has been pending.
OA has been disposed of.
OA filed by the bank is pending.
That's what I'm asking. You go make all these pleas there, sir.
My lord, OA has already been disposed of, my lord.
Disposed education matter is pending, na? It is connecting matter, my lord. Because still we have to get, my lord, if my lord will clarify, page 76 annexure 2 will be there. We have sold the property for 30,50,000 rupees. We have handed over possession. Everything is there. Only left over is the registration. That stage petitioner has preferred this writ petition. Then my lord has passed this order. So after deducting of that amount,
we have by 1/12/2011, bank has communicated that after adjustment of the 30 lakhs 50,000, you have further to pay 20 lakhs 80,000. And you pay to avoid further litigation in the matter. That is annexure 2, page 76. After that, this honorable court has been pleased to direct this order. And my say that now there is a, I have to collect the data because there is no dues in between. They have to collect it backlot. Things has been come. So today morning I have communicated them. Latest position, what we are discussing, this matter must not be adjusted in the further dues in the.
Not understood at all, sir, what you are saying. I have not understood what you are saying.
My lord, my page 76, annexure 2, bank has communicated by letter to the petitioner that after adjustment of the auction bidding amount of 30 lakhs 50,000, you have further to pay 20 lakhs 80,000.
So what happened to this purchaser of the property in the auction?
Auction purchaser is here. We have handed over possession.
So he's not interested in getting possession.
Sir, I am the purchaser since 2011, sir. But sir, they are not releasing deed in.
Can you just take off your mask, sir?
Sir, I am the bona fide purchaser since 2011, sir. But sir, the bank is not released deed in favor of me, sir.
You have not come to the court asking for vacation of stay, nothing. You're not interested, I think. You're not interested in the property.
I am this council from 2020. Previous council is not, sir.
So therefore, you have no interest.
He has been promoted, man.
So he has lost interest, therefore. Your client is not interested in the property.
I am lots of time knocking the door of the bank, sir.
Bank, the matter is pending here. What will the bank do?
The bank already said that if the case is adjourned by the court, so I cannot do nothing, sir.
And you believe that? As a lawyer, if the bank tells you they can do nothing, you can do nothing, you will accept that.
Sir.
You are the opposite party. There is a stay granted in favor of the petitioner. You can do nothing. Are you saying that?
I am interested to release a deed in favor of myself.
I have not understood what you're saying. Why are you swallowing words? Why don't you speak clearly?
Since I have purchased the property in the year 2011, and the bank has only given the sale certificate and possession of the property.
No. Are you interested or you're not interested?
I'm interested to purchase.
Where you have not filed any application vacating stay, nothing.
I am the bona fide auction purchaser.
So are you not interested in vacating the stay? No, not interested.
Interested, man.
When? Only after we ask you become interested. What is this, sir? If you're not interested, then why have all this? The petition can be disposed of.
I will file within 7 days, man. I will file within 7 days.
What will you file?
A vacation of interim order.
There's no need for now to you to do that, sir. We are ourselves seeing how we dispose of the petition. We're just asking you if you're interested. Have you spoken to your client at all?
Brief has been transferred.
Without meeting client, only brief came to you. So you do not know even who your client is.
During the COVID time, brief has been transferred to me, man.
So within COVID time, even phone call you should not make to your client. This is remarkable, sir. You've got a brief, but you have not got in touch with your client. This is remarkable. Was there a stay against you for contacting your client also? Was there a stay against you for contacting, saying you should not contact your client? He's not understood anything. He has to translate immediately. What is the position? How much have you paid? What is the total outstanding amount?
Out of 52 lakhs 11,490 NPA amount, I have deposited 45 lakhs 50,000.
That is the total amount, sir. When did you last make payment? After that, the interest is mounting. When did you last make payment?
My lord, as per direction of this honorable court, last time I have deposited
when? Date, sir.
17/1/2012, my lord.
12. How many years ago?
10 years.
10 years, you're also sleeping soundly. They are sleeping even more soundly, sir.
My lord, I am.
We also should go to sleep. What do you suggest? We'll all go to sleep. If this case had not been listed today, you're not bothered, they are not bothered, nobody's bothered.
If your lordship says last order, it was directed to list next week. Thereafter, it has not been listed.
It is only our problem, sir.
No, my lord.
Always
I
it's
am
our
saying-
fault. It's our fault only always. Never your fault. If you don't pay after 2012, it is not your fault. It is the court's fault. What is the total outstanding as on date?
Well, 1 week time will come. Because file has not been within, because file has shifted to right.
Sometimes I wonder why should the court break its head? We'll simply dispose of the petition because none of you is bothered. He is not bothered. He doesn't even contact his client. This man is not bothered because for 10 years, nobody is asking him to pay anything. So he's very happy. You are staying in the property.
No, my lord.
With whom is the property now?
I am in
Property is
possession.
with
I am in possession, auction purchase.
Only sale certificate has not been executed.
Sale certificate has been issued, possession has been handed over, only sale deed has to be made at that point of time, I don't know.
We vacate the
Lord,
stay. I
as
don't know.
per Honorable Apex Court's direction, I have right to redeem, my lord.
Not at your own choosing, sir. Whenever you feel like you cannot.
My lord, the client is litigating since 2010, my lord, for that reason. And the only house is involved in this case, my lord.
See, you have lost possession for over 10 years now. How can you get back possession now? After he has paid the entire amount in auction sale.
Lord,
That's not even reasonable.
After also auction the property, I have
Can't now
deposited.
throw him out. He's in possession for the last 10 years.
I have deposited 22 lakhs after auction.
Anyway, you owed the bank. You anyway owed the bank.
And
We can ask them to refund it to you if they have already recovered the entire amount from the other side.
No, my lord. My lord, by page only, my lord, I pray that kindly see that page 76 annexed 2. That after adjustment of 30 lakhs 50,000, we have communicated that you have further to pay 20 lakhs 80,000. Please pay it to avoid further litigation in the matter. Then after he has come to this honorable court and my lord was pleased to direct them to deposit 17 lakhs and subsequently 2 lakhs.
Which means it's over. The 20 lakhs is over.
Now we have got our money, total money. After payment of these 70 lakhs, 5 lakhs, we have got our total money.
Including the auction purchases
Auction
money.
purchase, auction
Oh. So anyway, he can't get it.
Your lords.
Not due. Auction purchases paid the entire due. We paid the balance. That's it. Yeah, because he's paid the entire amount. It's gone to him. So what remains in the matter then? You've got your entire dues. He has got the property. What remains in the matter, sir?
I have filed this writ application.
Sir,
to get
unless
back
you are able to pay off the auction purchaser, you don't have the money to pay off. Are you prepared to pay the current market value to the auction purchaser? You are in no position to do that. Where is this property located?
Bhubaneswar in the Denkanal district, my lord.
No. What is it worth today?
My lord, at the time of getting loan, the property was valued at 60 lakhs. And it
Today
was
it is in crores, sir.
it was sold at 30.50 lakhs. ma'am.
Whatever. You are not in a position to pay all that amount to the auction purchaser. With great difficulty, because of the court order, you paid him some 20 lakhs, the bank.
My lord, I am on the faith of getting the house.
So if you are able to pay the auction purchaser the amount he has parted with plus interest,
Lordship,
that
call
is
it
the,
day
what
after
is the amount
tomorrow.
paid by the auction purchaser?
30 lakhs 50,000.
So if you add some 10% interest on it, you won't be able to pay it.
I will take instruction, my lord. Your lordship, call it day after tomorrow. I will take instruction, my lord. The proper house is involved, my lord. For that reason, I beg.
10 years you've lost possession, sir. He's in possession for the last 10 years. Counsel, the petitioner wants to take instructions on whether the petitioner is in a position to pay the entire sum parted with by the auction purchaser. But you'll have to pay the current market value, I think.
Then
What is the house for residential?
Yes, residential house.
It's a residential house.
Yes, ma'am.
Together with
from the private part, it was bleeding, my lord. But the inquiry reports, the postmortem report shows, my lord.
postmortem is conducted by a doctor.
My lord, postmortem
Inquest
reports,
is not
those-
by a doctor.
my lord, from the postmortem report, though it reveals there was some stain marks, bleeding blood stain marks, and
You don't
there
know.
was some bleeding.
You
But
phenomenal photographic memory, sir. I don't have that memory. I'd like to read the document.
my lord, the document is there, my lord. Lord, may kindly peruse page 17, my lord. Page 17 of the writ petition, my lord. The postmortem report. The last portion, my lord. No external injury detected over the body except some tiny abrasions with mild blood stain to the extent, my lord, it is not visible, my lord, right eye, which may be due to postmortem, and that is not visible, my lord. But your lordship may see the inquiry report submitted by the jail authority. It is annexed at annexure B to the counter affidavit, internal page 9, my lord.
No, postmortem ant bites.
Due to
Sorry,
postmortem ant bites.
It is not visible, my lord.
Visible. Postmortem ant bites
ant
there.
bites.
Page 17.
Yes.
Yes, sir.
What happened to these viscera reports?
Viscera report was
Cause of death, the opinion as to cause of death is reserved pending chemical analysis of visceras. Page 54 is the viscera.
In Annexure 9, my lord, the jail authority conducted an inquiry, and here they say clearly it is stated, my lord. I didn't find any complaint neither from the SUTP Satyavrata Naik, the deceased, my lord, nor reported by any of your staff that if he had any health complaint, my lord. He was not having any health problem, my lord. But it is stated that due to high diabetic, he was died. I also relied upon the decision, my lord, delivered by this honorable court.
First, we'll come to decision later, sir. First, let us get the facts.
My lord.
What makes you, what is it telling you about the death? Is it a natural causes or what is according to you the cause of death?
According to me, my lord, due to heavy assault, he expired. My lord.
Not maybe assault, sir. When there's a doctor, how do you simply say this? Has the medical opinion said that?
The doctor has not opined.
Then how can you simply say that? The doctor has not opined anything.
During
You're not a doctor.
Absolutely correct, my lord. But inside the custody,
Everybody dying in jail will die only because of assault.
no, my lord. But when he was not having any health issues, my lord.
No, you can't infer these things, sir. That's why you have a postmortem. That's why you have doctors. These are not matters for inference.
Their authorities have conducted the inquiry and they say there was no complaint regarding the health issues, my lord. That is at Annexure B, page 9, the counter affidavit, my lord. They have annexed the documents.
No. How do you, from all this, how do you infer that he died because of assault? And assault by whom? Nothing.
Inmates,
That he died by assault. That's it.
Inmates, my lord. Inmates. Because
anybody. So you have no proof of all this. Simply you're guessing.
In the report, my lord, the inquiry conducted by the jail.
In the jail, there are only inmates. There is no warder. There is no superintendent.
Yes, they said.
There are no guards.
My lord, they said.
No. So on what basis you're saying inmates have assaulted him?
My lord, they say in their inquiry report, my lord, I am placing, my lord, Annexure B, internal page 9 of their counter affidavit, my lord.
Yes.
The lordship kindly peruse paragraph 3, my lord.
Yes.
On 36/2009, my lord, with the date is relevant, my lord, on this date, the petitioner expired, the petitioner's son expired. I have attended the unlocking along with my assistant jailer, head warder, in charge Sudhir Kumar Jana, warder such and pharmacist Sri Purnachandra Barik was also present at the time. The SUTP was confined in ward number 2. I also attended the lockup along with Sudhir Kumar Jana, in charge jailer, assistant jailer and pharmacist. The duty head warder and warders with effect from 12 o'clock to lockup were also present at that time. I did not find any complaint, neither the SUTP nor reported by any of your staff that if he had any health complaint, only in the night when health condition of SUTP Naik was suddenly serious.
No. So from this paragraph, you want us to infer that some inmates assaulted him. From this paragraph.
Lord, even if he was suffering, my lord, it was the duty of the jail authority to provide him better treatment, my lord.
Sir, I am on a specific question here. According to you, he was assaulted by inmates. That's what you are saying.
Maybe, my lord.
What is this maybe? From what you're reading now, where do you get that?
How I will know, my lord.
Exactly. So don't guess. Your correct answer should be,
yes.
I don't know.
I don't know, my
lord. You are not saying that. You're simply suggesting some inmates assaulted him.
And the very next page, my lord, page 10, the lordship may kindly see.
Sir, this is not a guess game going on here.
No, my lord.
We are on some serious issue here.
Yes, ma'am. I am only placing certain facts from their report, my lord.
You are not just placing facts, sir. You are trying to draw very serious inferences.
No, ma'am.
Yes.
Sorry, ma'am.
Where is that? Come to page 56, that's the final medical opinion.
Yes. Opinion of the jail medical officer, ma'am.
The present petition has been filed seeking compensation of rupees 5 lakhs for the single quotes unnatural custodial death of the son of the petitioners in the Champua sub-jail on 1st July 2009. Stop. Paragraph. The background facts are that the son of the petitioners was first remanded to judicial custody in the above jail on 15th March 2007 by the order of the SDJM Champua in GR case number 38/2007 under section 376 IPC. Full stop. Subsequently, the case was transferred to the additional sessions assistant sessions judge, learned assistant sessions judge Champua in ST case number 31/134 of 2007. Full stop. Paragraph. It appears from the reply filed by the opposite parties that while in jail, the said under trial prisoner suffered from malaria fever, for which he was admitted to the subdivisional hospital Champua on 5th September 2008. Full stop. On 9th September 2008, while undergoing treatment in the hospital, it was medically detected that he was suffering from diabetes, and he was thereafter being administered medicines regularly for the said condition. Full stop. Paragraph. It is further stated that on 1st July 2009, between 12 a.m. and 12:05 a.m., while he was in Ward 2 along with 5 other UTPs, he became seriously ill and suddenly developed convulsions, for which he was immediately shifted to the SD hospital Champua, accompanied by jail warders / guards. Full stop. It is then stated as under, just from page 22, from the 5th line, no, not 5th line, 10th line. After being admitted, he was treated properly, particularly the part-time jail medical officer. That onwards, declared dead at 12:45 a.m. on 1/7/2009. Till that. Give me the hard copy. A to A, page 20. Paragraph. The postmortem report did not indicate any external injury, except some tiny abrasion with mild blood stains found near the outer angle of the right eye. Stop. The perusal of the said postmortem report reveals that, according to the doctor, this might possibly be due to postmortem ant bites. Full stop. Paragraph. The perusal of the postmortem report further reveals that the cause of death was reserved pending the chemical analysis of the viscera. Paragraph. The counter affidavit also encloses the viscera report which reveals that
It's paragraph 7 of the counter.
yeah, no chemicals, alcohol, insecticides, alkaloidal, or metallic poison could be detected in the viscera. Correct. After the aforementioned viscera report, the doctor gave the final opinion as under B to B. It appears that in between the National Human Rights Commission had also inquired into the matter. And found the and observed as under C to C. Counsel for the petitioner refers to the inquest report. Which page is the inquest report? Where did you get the it showed that there were bloodstain marks on the backside of the neck, ear, eyes, nose, and private parts. However, it's seen that there is an explanation offered for this in the postmortem report. Full stop. It must be noted here that the postmortem was conducted by two doctors, Dr. G.C. Rao and Dr. G.C. Pati of the Subdivisional Hospital, Champur. Full stop. Although counsel for the petitioner wants the court to infer that death was due to the assault by single quotes inmates, unquote. There's nothing on record to remotely indicate that there was any such assault on the petitioner. So no injuries, either external or internal, have been detected in the postmortem report. Also, the magisterial inquiry held in the matter did not disclose any foul play or attack of the inmate by anyone. There appears to be also no undue delay in extending treatment to the inmate, to the deceased inmate. In the circumstances, the court is not satisfied that any case has been made out for granting the relief as prayed for. The petition is dismissed.
My lord, the power of Devashish Tripathi and associate be ignored, my lord.
All right.
Weekly list. Weekly list fresh admission item number 1.
Pardon, my lord. Item 1, my lord. Delhi Weekly. My lord, the brief has been transferred.
All right. Counsel states the brief has been transferred. None appears dismissed.
Weekly list item number 2.
None appears dismissed.
Weekly list item number 3.
None appears dismissed.
Weekly list item number 4.
Item number 4, I am in BC, my lord. On behalf of Ms. P.B. Das, CMPL filed to restore the case.
What's the main case about?
My main case is regard to discharge of a candidate peer, my lord.
Discharge
of a candidate peer in the justice of Bhadrak, my lord. He has been discharged.
Page 5, my lords. The post has been discontinued. So his prayer for reinstatement, my lords, doesn't survive.
Well, that is correct. But in a similar case for justice of Jharsuguda, this court has directed in a division bench that they can be absorbed in any class 3 post, my lord. My associate is there, he will supply the hard copy, my lord. In the division bench decision. Due to his absence, she could not place that. Let me see that.
The reason stated, the orders, the application is allowed. The order dated. Well, 1 minute. This is for recall of 12th April 2022.
Yes, ma'am.
12/4/2022.
Where's the occasion for recall, sir?
My
this was passed in your presence?
No, she was not present. So he's one of friends seek for time that after this order was passed.
No, that's not a thing for recall of. This is not some dismissal in default. I'm sorry, this is not a dismissal in default.
I have filed on affidavit that one of his friends request for adjournment after this order was passed.
No, but this is not. You can't file a CMAPL for this, sir. Sorry. How can you file a CMAPL for this?
Well, that is almost young counsel. He could not.
No. That is not the CMAPL. Sorry.
That should have been recalled.
No. How can we set aside? This is what kind of a prayer is all this?
But not set aside.
Then you either file a review or you file an SLP. Not CMAPL. I don't know how they numbered this. This application.
Could not be placed, my lord.
No. Sorry. That's not. Then you file a review, not a CMAPL.
With that observation,
no observation. This application is thoroughly misconceived. It's dismissed as such.
Weekly list item number 5.
Item number
May I
5
please,
and
Lord?
6. My
Already, my lord, notice has been issued in similar matter, my lord.
here, my lord, my preliminary objection with regard to delay and laches, your lordship may also consider, because 2016 notification has been challenged in 2022.
Well, exactly in a similar matter, lordship was pleased to issue notice, my lord.
This and the next matter both?
Yes, my lord.
Both.
5 and 6.
All right. List on 22nd August. Notice he accepts notice. Simply say list on 22nd August.
Mobilized, my lord.
Weekly list item number 7.
My lord, posted to 22nd August.
May I
Item
please,
7.
Your Lordship? Item 7, Your Lordship, Annexure 1 series pending before the OP2 is a PIL. The petition is a polluted spirited person filed this PIL regarding challenging the enhancement of users fee and holding tax in the BMC area, Your Lordship, Parampur Municipal Corporation. Annexure 2 is pending before the BMC. That may be considered, Your Lordship.
What is that to show it has been delivered?
My Lordship.
Acha, that receipt is there. Okay. Petitioner's representation. Annexure 1 series. Be examined by the
OP2, Your Lordship.
Commissioner of Berampur Municipal Corporation, and after hearing the petitioner, a reasoned order shall be passed thereon not later than 1st November 2022. Copy of this order should be sent to opposite party number 2 forthwith for compliance. The opposite party number 2 will intimate the petitioner the date of hearing at least 1 week in advance.
Weekly list item number 8.
May I please, Your Lordship? There is a proposal of opening of a second Kendriya Vidyalaya at under civil sector Champua. Thereafter the land was acquired at Ramlal. Thereafter it was shifted to Kalika Prasad, which is 11 kilometers away from the Champua, my lord. Therefore, present petitioner approached the collector with the representation. Thereafter approached this honorable. Your Lordship had order dated Annexure 7, my lord. Order dated 3/1/2022. Direct the petition to approach the collector as usual Kendriya Vidyalaya Sangathan, my lord. Thereafter, petitioner approached, and while disposed of the representation, the collector disposed with the observation that if sub-collector Champua notify some new places, then the Kendriya Vidyalaya will take a decision. Thereafter, sub-collector by Annexure 10, my lord, submitted 6 place, and Annexure 11, my lord, page 47. The Kendriya Vidyalaya Sangathan disposed of the representation with a observation that the last 2 paragraphs, my lord. For consideration of proposal submitted by sub-collector Champua by letter dated so and so, a proposal is Annexure 3 is required to be submitted by you, means my lord, my collector, my lord, through the secretary, as government of Orissa, my lord. In view of above, it is stated that if the earlier proposal land measuring 8 acres at village Kalika Prasad, Khata number 324 is cancelled in writing by the government of Orissa, then only the proposal submitted by the sub-collector will be considered, my lord.
So what's wrong with this?
The collector will be, my lord, through Annexure 3 will required to be submitted, my lord. Sub-collector already submitted the proposal. Out of, my lord, 4 moja, there is 8 place, my lord. Annexure 7. And the Kendriya Sangathan will only say that will be through collector will be submitted.
The recommendation made by the sub-collector on 22nd June 2022 will be considered with the district collector, bracket Annexure 11, will be considered with the district collector, and a decision shall be communicated to the petitioner thereon, not later than 10th October 2022. No further directions are called for. The petition is disposed.
Weekly list item number 9.
Your Lordship, may I please, Your Lordship? Your Lordship, I am on behalf of the petitioner, Your Lordship, in this case. In this case, the notice under section 148 has been challenged on 2 grounds, Your Lordship. The first round is it is 2015-16 and 31st March 2021. The notice has been sent with the approval of additional commissioner. And the second issue, Your Lordship, second round of objection, Your Lordship, challenge, Your Lordship, change of opinion, Your Lordship. And so far the change of opinion, same set of facts, same set of documents, assessing officer in 143.3 has adopted a method of addition and has made the addition. And the assessing officer has sought for another software, want to substitute it, another method, Your Lordship. Your Lordship, can I place, Your Lordship, the...
No. He's not here, my lord. The assessment order has been passed, my lord.
Oh.
He has not never participated in the assessment proceeding.
It's already, if the notice is bad, it's bad.
I understand that this notice is not permissible But notice has already issued, it is covered by this order. And your lordship see the order, he has never appeared in a single notice. And now we come up with the case that is change opinion. It is not at all a change. I'll file a small affidavit or keep it another day. I'll file a small affidavit.
No. If it is hit by Ambika and still that's the end of the matter.
That is a notice, Milord. The notice part over, Milord. The assessment order has been passed in this present case. Therefore, Milord, I humbly pray, Milord, one spot. Your lordship may admit it, Milord, protection may be given, but I will allow me to file a short.
In all these cases, your lordship assessment orders have been passed. In Ambika, your lordship might have remembered. In Ambika, all the consequential assessment orders and demand notice have been passed. And in Ramkumar also the same thing has been happened.
Of course, the root of the matter.
Squarely covered.
But I take instance, otherwise, Milord.
What is
in all?
Milord, all cases, your lordship disperse, Milord.
Yeah. In the impugn notice under Section 148 of the Income Tax Act 1961 has been issued on 31st March 2021 with the satisfaction of the additional CIT, yes, bracket range 1. And therefore, clearly, the notice is bad in law. Following the decision of this court in Ambika and Steel Private Limited versus Principal Commissioner of Income Tax, bracket, order dated 24 January 2022 in Red Petition 720919 of 2021, bracket, the impugned notice is held to be bad in law. The consequential assessment order and further demand notice are all hereby quashed.
Your
The
lordship,
petition is disposed of.
consequential penalty proceeding.
Yeah, and consequential penalty proceedings are hereby quashed.
Weekly list for orders, item number 10.
Let's in view of the noting that the address expired, nothing survives in this.
The address is expired. Nothing survives in the present petition. It's disposed of. It's dismissed.
Weekly list, item number 11.
Same order.
No. So there are 4 opposite parties. Open number 3 has expired.
Okay. But
And
this is a
open number
2008
one-
matter, sir.
Open number 1 to 4, despite receiving notice, plus they are not appearing. Notice is sufficient, plus.
Okay, it's a 2008 matter. Tell us.
Plus, AD back from OP number 1, 2, and 4.
Right, sir. It is a 2008 matter. Tell us what it is.
No, they are not appearing, and there are direct evidence against them.
Let us see what it is. We haven't seen the matter.
My lord.
Date of judgment is 27/7/2007.
My lord.
And when did you file this?
That is true, plus on the question of limitation notice has been issued, and that is
Limitation is how many days?
Pardon me?
Delay has been condoned already. No, has delay been condoned?
My lord.
Oh, it's already been condoned. Okay.
I'm not sure, Lord.
Yeah, delay has been condoned.
Delay must be because AD back from open number 1 to 4. That's the reason why they are not appearing. Plus on merit plus PW 3, 4, and 5. They are the eyewitnesses, plus. And PW plus I am taking a lordship to paragraph 7 of page 6 of the internal page 6 of the judgment. There is the opinion of the medical officer who has been examined as PW2.
Yes.
During paragraph 7, the medical officer who conducted autopsy over the dead body of the deceased has been examined as PW2. During PM examination, he found the following external injuries. They are the injuries, 3 injuries lost. And according to his opinion, all the above injuries were antemortem in nature and death was due to above mentioned cerebral injuries as a result of blunt force trauma on head. His report of postmortem examination has been marked as Exhibit 4. So there is this is a homicidal death. Then I am taking a lordship to page 9, paragraph 16. This paragraph 10 plus, beg pardon, plus, that is PW4 is another son of the deceased who claims as an eyewitness to the fatal blow to Kirtan. He is also an injured of this case. According to his testimony, while Rajendra, informant, was going by his motorcycle, accused Suresh obstructed him. As deposed by him, hearing the noise, he came and saw the incident at a distance. He has further deposed that on his side, all the accused persons left his brother and assaulted him. It is not his version that he rushed to Rajendra to rescue him as described in the FIR. Similarly, PW4 doesn't say to have arrived at the spot as has been testified by PW3. The presence of PW4 at the time of occurrence accordingly Plus, he has not doubtful. It is his further testimony that when his father Kirtan was to the spot, accused Girish gave a kati blow to his father and accused Mahesh dealt a stroke by means of Pattakavadi to the head of his father and accused Suresh assaulted his father by means of Thenga. Similarly, as reported by a co-villager, P 5, because it is important. Accused Girish was holding a Khandakati, accused Mahesh was holding Pattakavadi, and accused Suresh was holding a Thenga, and by means of said weapons, they assaulted Kirtan Maharana. As seen from his cross-examination, Kirtan was assaulted by one stroke with the help of Khandakati, 2 strokes by means of Pattakavadi, and 2 lattice blows. If his evidence is accepted, Kirtan must have sustained 5 definite injuries. Basing upon this, the order of acquittal has been.
Yeah, why not? Because ultimately, the medical opinion has to corroborate the eyewitness testimony.
Plus, here these persons, they are rustic villagers, and they
rustic is one thing, sir.
And this is Khandakati plus. It has got a sharp edge, also has got a blunt edge. So this is not the case.
No, but he's not saying he was assaulted by a blunt edge and all. For that, you have to cross-examine him properly.
Plus, I am if you also permit me, I can show the deposition of P 5 and P 2. You'll also can peruse because I have not supplied. Plus, I can show it just now. Plus, that is
all
with
right.
me.
You read it out.
I'm reading P 5. Plus, I know all the accused persons. I know this is Kirtan Maharana. I know Rajendra Maharana and his brother Pradeep Maharana. The occurrence took place on 2nd July 2003 at about 8 a.m. At that time, Rajendra Maharana was going in his motorcycle in front of our house. While Rajendra crossed our house, accused Suresh came out from his house holding a thenga, shouting, some slang language has been used, and gave a kick blow to his motorcycle, as a result of which Rajendra fell down. At that time, I was standing at our outer veranda. The distance between the spot and occurrent veranda where I was standing is about 30 feet. After Rajendra fell down, Suresh assaulted him by means of a thenga. At that time, Pradeep Maharana was coming from backside. Seeing him, Suresh shouted, again slang language has been used, and immediately accused Girish Samantray and Mahesh Samantray rushed towards Pradeep Maharana. Accused Suresh also rushed to Pradeep Maharana, leaving Rajendra Maharana. In front of our house on the road, the above said 3 accused persons assaulted Pradeep Maharana. To his head, back, leg, as a result of which he sustained bleeding injuries and he became naked. Seeing the incident, Kirtan Maharana rushed to the spot. At that time, he was trying to lift his son Pradeep. Accused Dibakar Samantara came and caught hold him from his backside, and other 3 accused persons assaulted Kirtan Maharana. Accused Girish was holding a Khandakati. This Khandakati has got a sharp side, also has got a blunt side. And Mahesh Samandra was holding a Pattakavadi. Accused Suresh Samandra was holding a Thenga. And by means of said weapons, they assaulted Kirtan Maharana. I shouted as Marigala, died. Thereafter, all accused persons left the spot. Thereafter, I administered water to Kirtan Maharana, and thereafter, Kirtan Maharana was shifted to Purushottam Hospital by auto. On the next day, being called by the police, I had gone to the Purushottam PS. This is the deposition of P 5 and P 3 also. Categorically deposed against.
Opinion says injury 1 or injury number 2 is not possible by a sharp cutting weapon.
Plus, the London trial court has taken a view because it doesn't corroborate the medical evidence. Basically, about that only order of acquittal has been passed.
Yeah, it's a plausible view, sir. The state seeks to appeal against an order dated 27 July 2007 passed by the ad hoc additional sessions judge in sessions case number 30 and 34 of 2004, acquitting the respondents of the offence under section 302 IPC, punishable under section 302 IPC. Paragraph B. Case turned on eyewitness testimonies of PWs 4 and 5, who attributed sharp-edged weapons to each of the respondents in their attack on the deceased. The post-mortem report, however, indicated 2 cuts on the scalp, which and the cause of death was stated to be the aforementioned cerebral injuries. Full stop. The trial court on careful analysis of the evidence of PWs 4 and 5 found that the testimonies are not corroborated by the medical evidence and therefore gave the benefit of the doubt to the accused. Having carefully examined the judgment of the trial court in light of the submissions made by learned counsel of the state, the court is not persuaded that the view taken by the trial court is not a plausible one to take in light of the evidence placed before it. Consequently, the court declines leave to appeal against said judgment. The petition is dismissed.
Weekly list item number 12.
May I please, my lord? This is departmental proceeding, my lord.
Yes.
Yes. My lord, page 30, annexure 4. This is the original initiation of a departmental proceeding on the ground of unauthorized absence, my lord. Thereafter, my lord, petitioner submitted the show cause reply. After that, my lord, may kindly see the manipulated charge, annexure 6, page 37, my lord. Page 37 will clarify that. Once I submitted the show cause, that charge should have been dropped. But instead of dropping the charge, they have initiated by correcting the charge sheet, my lord. May kindly see the manipulated charge, annexure 6, page 37. The same similar cause of action, my lord, by only on the ground of unauthorized absence, my lord. My lord, here the petitioner is Salary Amino, very low-paid employee of the Baleswar district. He retired in the year of 2018, my lord. But his punishment has been imposed with the toppage of 2 increment with a cumulative effect. That is the only ground, my lord. Another punishment was that unauthorized absence is no work, no pay, which should have been treated as leave, my lord. That is only submission, my lord.
What do you say?
Well, it's
Is it not disproportionate for unauthorized absence? Unauthorized absence for how many days?
My lord, approximately 6 months.
Unauthorized anticipating a transfer, my lords.
Unauthorized absence, my lord, it is supported by medical certificate. Medical doctor has been examined, my lord.
My kindly see page 71.
The doctor has also been examined in this case.
He was supposed to join on 14th of September 2006.
Yes.
Ultimately, he has joined on 8th of March 2007.
Yes.
Oh. Then it's correct only, sir.
And Millers, the appeal committee has page 108. They have perused the.
There
order
are 300
that
leaves at his credit. 300 leaves at his credit that should have been treated as a leave due, my lord. Without treating this leave, they have stated
You can't
that
simply unauthorized leave, you can't remain.
My lord,
You can't remain unauthorizedly on leave and then say you adjust my pending leave.
no,
against
my
that.
lord, it is not unauthorized, my lord. It is only on the ground of a father's illness,
No,
my
no,
lord.
no. Did you seek permission? One, did you get the leave sanctioned?
No, leave has not been sanctioned because
then,
leave was
then
refused.
where's the question of this not being unauthorized?
My lord, page 80, page 81, page 81, final order, may kindly see. Page 81, annexure 13, my lord. Only one line, this is punished. This punishment is imposed. No other orders, no other communication has been made. And the petitioner is very poor salary, my lord. It's equal to class 4.
No. 6 months absence is not an easy thing, sir.
That is the only submission, my lord?
Yeah. There is only one submission made by learned counsel the petitioner, namely that the punishment of withholding of 2 increments with cumulative effect for unauthorized absence is disproportionate. Paragraph. In the present case, the unauthorized absence was for a period of 6 months from 11th September 2006.
14th September 2006.
Till
8th of March 2007.
8 March 2007. This long period of 6 months was without any prior permission or even getting the approval of the competent authority. Consequently, the court is not persuaded that the punishment awarded for such unauthorized absence for nearly 6 months
My lord, no work,
Is
no pay punishment that may be modified.
Is
My lord.
disproportionate and requires any modification. Consequently, the writ petition is dismissed.
My lord, no work, no pay punishment may kindly be modified. But
sorry,
that is
sorry, sir. Sorry.
Item 13.
May I please your lordship? My lord, this is a PIL filed by the petitioner and different organization of the Barampur city, my lord. The Barampur city, my lord, 12 lakhs people are staying in this Barampur city, the highest populated city of the state, my lord. One of the highest populated city, my lord. My lord, there is no RTO office. They are demanding the first opening of RTO office. They made representation. And in this verge of this on 20th June 2017, the extraordinary meeting was held for discussion of
So
proposal.
even till today, 5 years later, no RTO office.
My lord?
5 years since you filed this writ petition, even today, there is no RTO office.
My lord, this is the case of 2020, my lord.
All right. Till
Yes.
today, there's no RTO office.
No, my lord.
All right. Your representation is 5 years old, sir.
Yes, already I have filed the representation.
After 3 years, you filed the writ petition.
Yes, on 2017, my lord, the extraordinary meeting was held under the
petitioner's representation be examined, bracket Annexure 1 series. Is there anything to show you have delivered these representations?
Well, Annexure 1 series, my lord.
Kindly show proof of delivery of representation.
Yes, my lord, that acknowledgement, postal acknowledgement, I have not annexed.
Then you make a fresh representation. Anyway, that representation is 5 years old, permitting the petitioner to make a fresh representation to the authorities concerned. Court disposes of this presentation.
Weekly list item number 14.
Obliged.
Item
None appears
14.
dismissed for non-prosecution.
Weekly list item 15.
This would be infructuous.
All right.
Yes. This is PIL, my lord. With a prayer that the opposite parties be restrained from constructing the dry threshing floor over the said land, because the said land is being used by the villagers for the communal purpose. That
So
is
this is a 2018 order, sir, work order. By now it will be over.
Page 11, my lords. The terms and conditions says the work must be completed on or before 31st of January 2019.
19.
Yes,
right. Due to passage of time, the present petition has been rendered in practice. It is disposed of as
but
such.
it is not yet been completed.
Yes.
Weekly list item 16.
My lord, may be permitted to withdraw with liberty to file better application, my lord.
Or counsel the petitioner seeks leave to withdraw this petition with liberty to file a better application.
Weekly list item 17.
This withdrawn with liberty.
Item number 17.
None appears dismissed for non-prosecution.
Weekly list item 18.
Yes, my lord. Petitioners are the farmers of some villages without irrigation of water. Their concerned collector is compelling the farmers to pay the water cess. When farmers fail to
what is the proof of delivery of this representation? Come to page 18.
Though there is no any endorsement, but farmers made to authority and
No. You just make a fresh representation, permitting the petitioner to make a fresh representation in accordance with law. And after following up on such a representation, to seek appropriate remedies, the petition is disposed of.
Weekly list item 19.
No instruction, my lord. No instructions dismissed.
Weekly list item 20.
Yeah, I permitted the withdrawal to file a better petition.
All right. Counsel the petition seeks leave to withdraw this petition, liberty to file a better petition.
Weekly list item
Dismissal is
21.
withdrawn with liberty.
Maybe permitted to withdraw.
All right. Counsel the petitioner seeks leave to withdraw this petition, dismisses withdrawal.
Weekly list for admission item 22.
In this case, there is a strong point. We'll get it from internal page 20 of the judgment, paragraph 11. Plus, due to absence of motive, a case of murder has been scaled down, section 304 part 2.
That's okay.
Page 11, boss. Paragraph 11, page 20. During course of argument, it has been submitted on behalf of the defense.
Government. Page 20.
Page 20 plus paragraph 11.
Yes.
During course of argument, it has been submitted on behalf of the defense that even if the prosecution case is accepted for argument's sake, that the accused had assaulted the deceased by means of bhujali on his abdomen and right arm, and injuries were the cause of death of the deceased. In absence of any motive, the accused cannot be found guilty under section 302 of the Indian Penal Code. And at best, he can be found guilty under section, either under section 302 part 1 or part 2.
No, let's see the postmortem, sir. How did it occur? How did the evidence
Eyewitness was PW6.
No. How did the let's see PW6.
PW6 and PW10.
All right, let's see that.
10 plus you'll also get it from page 19, paragraph 10. Just previous page plus. PW10, who is the daughter of PW6 and sister PW7, has stated that hearing hallas, he came outside and found the accused assaulting the deceased by means of bhujali on his abdomen and also on his right arm. Similar criticism has been made by the defense as regards the oral evidence of PW10 is concerned. Inviting the attention of this court to the evidence of the investigating officer PW17 in the cross, it has been argued that in view of the admission of the investigating officer that PW10 didn't specify the state before him, the accused stabbed the deceased on the right side abdomen and other part of the body, nor evidence also cannot be accepted. No doubt the investigating officer has stated that PW10 specifically didn't state that the accused stabbed the deceased on his right side abdomen and other parts of the body, but her evidence cannot be thrown out from consideration. The evidence of PW6, 7, and 10 is that the deceased was watching TV in their house, and after arrival of PW6, the deceased left the house, and immediately the PW6, 7, and 10 heard alarm of the deceased, and when they went outside, they found the accused chasing the deceased and giving blow on his right arm by means of bhujali. The other witnesses who were disbelieved as regards dying declaration have been deposed that they saw the deceased lying in a pool of blood in front of the house of one Gangadhar Mishra. This aspect of evidence led by prosecution has not been shaken. Here is no ground to disbelieve the evidence of PW6, 7, and 10 as regards assault made by the accused to the deceased. No doubt there are some discrepancies in the evidence of PW6, 7, and 10, and in my opinion, those discrepancies being minor don't shake the basic version of the prosecution case. It cannot be taken into consideration to record a finding.
So this is not a direct evidence case, or is it? These witnesses rush outside and see the assault, is it?
Yeah. Came out of the house because came out of the house and saw the deceased, being chased by the accused, and the accused assaulting the deceased subsequently. And the doctor has been examined as PW14. You'll also get to page 5, paragraph 6. You'll also see the external injuries, internal page 5 of the judgment. And then continue in page 6. The stab wound over the right side upper abdomen. And then penetrating wounds over the right arm. The spindle received inside wound on the right arm. And page 7, the opinion of the doctor.
You are for the opposite side.
Yes, Milord. Milord, my stand in this case from the beginning is completely denied. Milord, the first part is that there is no eyewitness to the occurrence, and I was not there in the place. Second thing, the weapon of offense has not been also seized by the prosecution. Third part is that, Milord, that basing on the prosecution witness, I have already undergone 7 years of imprisonment under 304 part 1. And due to my good conduct also during my imprisonment, I have been released prior to that, before 3 months, 9 days from the custody. My lord, the fact behind this case, there is no motive.
And he got released in 2012.
My lord, I got released. I got released in the year 2008, 21 April 2008. My lord.
8 itself.
Yes, my lord.
After 14
I was under surrendered on 30th July 2001.
The state seeks to leave to appeal against a judgment dated 21st May 2005, passed by the Session Judge Cuttack, convicting the respondent of the offence under Section 304, Part 1 of the IPC, and sentencing him to imprisonment for a period, rigorous imprisonment. Part 2, is it?
Part 2.
No, but I don't know if it's typing error. Come to page 25.
Was part 2. I'm showing the part of the judgment.
Acha, part 2. No, but in the next page, just see page 25.
Sorry. Part 1.
Part 1.
7 years for commission of offence under Section 304, Part 1.
Part 1, that's what. IPC, and sentencing him to 7 years rigorous imprisonment. Paragraph. As it turns out, during the pendency of the present appeal, the respondent served out the entire sentence and earned a remission of 3 months and 9 days for good behavior, and is out on jail on
21st April 2008.
21st April 2008, that is more than 14 years ago. Full stop. Further, on examining the trial court judgment in light of the evidence discussed, the view taken by the trial court appears to be a plausible one and does not call for interference. For all the aforementioned reasons, the court declines leave to appeal to the state, and the petition is dismissed.
Now, let me clarify that finding. There was absence of motive. 302 has been scaled down.
No, we're not. There's not going to be some reportable precedent or anything.
Quickly list item number 23.
23, my lord, is the petition challenging the award dated 36/2011 of the industrial tribunals.
Before that, madam, the my writ application is dismissed for default. Therefore, I feel like it be restored fast. And let's fix a date so I can give judgment. Issue is very limited. 2 issues. The petitioners have completed around 10 to 12 years of service. Retrenched in 2006. Tribunal award that the termination is illegal, violation of 25F. However, denial reinstatement. I am on only limited prayer that I should be reinstated since termination is illegal. For that purpose, now decisions are of the
what was the compensation awarded to you?
1 lakh.
1 lakh.
1 lakh. And government, employer is the government. And after my retrenchment, hundreds of persons have been appointed.
No, but you're not a regular employee. You're NMR.
NMR. All are NMR.
Project NMR.
But the employer is the government, and it's the perennial nature. Work is perennial nature. Not that it can be confined for years or 2 years.
No. How many years did you work?
I have 10 to 12 years. That is the finding of the tribunal.
So 1 lakh in 2012 is not a small sum, sir. In 2012, 1 lakh was not a small sum.
That please, that since we are unskilled, we must have employed otherwise. That is the reason.
1 lakh is all right.
I love the finding.
And there's a whole line of cases about reinstatement not having to be mandatory.
But the apex court was I will cite some authorities then tomorrow after.
May I first?
They have said that
there has to be engagement.
It depends on the facts circumstances. Suppose if 2009 relied upon by the tribunal, where the employee has completed less than 1 year.
No, 1 lakh is given, sir. 1 lakh in 2012 is not a small amount. 2012, 1 lakh is a reasonable.
11 claimants, my lord, 11 claimants have approached the London Industrial Tribunal, out of which 5 were held. It has been held that they were never engaged at all. The 6 for whom award has been given, the tribunal has on a basis of presumption given it in so many words. The tribunal stated that it is presumed. The claimants have not proved their case.
We'll restore your case, but both petitions are dismissed. That CM appeal is allowed. That order is recalled as restored to file. And a common order in both these. Dismissed. Both.
I agree one thing, my lord, it was 1 lakh in 2012. We are in 2022.
I know.
Therefore, Lordship say something, some modification of.
No.
compensation, my lord.
May I at least,
Or minimum interest, lordship say. I mean,
You say the amount we paid with interest.
from 10 years we are, my lord.
6% simple interest. All right.
14. My lord, may I just 2 lines I'll show, then if my lords want to pass that order, my lord will pass.
All right.
Page 14.
Yes.
The award of the tribunal, running page 14.
Yes.
About my lord, para 8
Yes.
was the last part. In the absence of pleadings. My lords could get it?
Yes, yes.
In the absence of pleadings and evidence as to the actual period of their respective engagement, it is to be presumed. So there is no pleading. There is no
even by
document.
you. The point is, pleadings means not just his pleadings, your pleadings also.
We have taken
You have the record, sir.
We have taken a
You could have easily
specific stand.
demonstrated by producing the record what the exact period of engagement was. That's what the guesswork has to be.
Well, their case was that they are continuously engaged.
No, usually records are kept by you. These are all helpless workers. They don't have any access to your records. All right, we'll see. Same.
Issue list item 24.
May I please your lordships?
Yes.
My lord, your lordship may kindly see the order dated 28/6/2022.
Yes.
When notice was issued to the opposite party and the valid service is there, but he is not. Nobody is appearing for the workman. It's a case, my lord.
Yes.
The workman he joined the service of the petitioner, my lord, on 7/6/2004, my lords. And after 2.5 years, he was.
I'm not seeing the order. I think it's scanned. Oh. No, is it now served?
Yes, it has been served. Noting is there, my lords, in the cause list, my lords, in spite of valid service.
All right. What does it award say?
No, award has not been passed, my lords. Here, my lord, case is that the workman joined the petitioner establishment on 7/6/2004 and he was terminated from service on 22/1/2007, my lords. Just 2.5, maximum 2.5 years, my lords. But here, my lord, the case of the petitioner is that he has undertaken the work of solid waste management by the Puri municipality, my lords. It belongs to Puri municipality, and annexure 1 is the contract or the agreement for 8 years, 2008 to 2016. So, my lord, the petitioner filed an application to implead Puri municipality because of, for the effective award, he filed an application under annexure 4, my lords, to implead Puri municipality. And that was rejected by the annexure 6. That is the case, my lords. Annexure 6 has rejected. The London Labour Court has rejected the application.
Let's see the order.
My lord, annexure 6. Your lordship may kindly see annexure 6, page 25, my lords. Should I read, my lord?
Yes, please.
On perusal of the case record, it appears that this is a case referred by the government under subsection 5 of section 12, read with clause C of subsection 1 of section 10 of the ID Act. From the date of appearance till today, no such petition was filed by the management to implead the executive officer Puri municipality in this case. During the course of hearing, the management filed a petition to lead evidence first in this case, and accordingly, the petitioner was also allowed. Direction was given to the management to lead evidence first in this case. On the date of hearing, the management, without adducing any evidence, filed the present petition. Such a plea has been taken by the management in the earlier occasion. There is no material on record to suggest that the executive officer Puri municipality is the necessary party in this case. The document filed by the management, that is the agreement, also does not disclose the same. In this view of the matter, the petition filed by the management stands rejected. Now, my lord, this agreement is annexure 1.
Yes.
Your lordship may kindly see annexure 1. Annexure 1, page 10, no, sir. Annexure 1 starts at page 6, my lords.
Where do you want to read?
My lords, I want to read there, whereas the first party being the owner, first party is Puri municipality. First party being the owner of the factory's solid waste management project at Baliapanda Puri wants to license out the project for a period of 8 years to the second party. Second party is the petitioner, my lords. So this was very much there before the London Labour Court. And my lords, if your lordship kindly see that the obligations of the parties in paragraph in my lords page 10, my lords, page 10, paragraph J, it is there. This is the obligation of the second party. I mean, this petitioner. Petitioner will have the liberty of paying for all the statutory obligations, taxes and fees pertaining to smooth operation of the project, and liable to be paid by the first party. Liable may entitled to be paid anyway. Liable to be paid by the first party, and thereafter claim the same from the first party or deduct it from the payment to be made by them. So this was there before the London Labour Court matters. And my lords,
no, this is about statutory obligations, taxes and fees, sir.
And ultimately it is to be paid by the Puri municipality.
No, what has that to do with a labor dispute?
No. Whatever payment is made by the petitioner, my lords, that has to be paid by the Puri municipality, my lord.
That is later. Right now, what is the dispute in the labor court?
The dispute is termination. Termination of the.
So how has that to do with all this, sir? Nothing to do with this.
This is the case, my lord.
No, there's nothing. You say this present petition has been filed challenging an order dated 16 March 2013, passed by the Labour Court Bhubaneswar. In restoration, this case 15 of 2011, arising out of ID case number 22 of 2009, praying that the executive officer, Puri municipality, should be implemented as a party.
From 16, my lord, from 16, I am not there, my lord. From 16th, the petitioner is not there, contract is over. Again, it has been gone to Puri municipality. So that's
all right, sir. Now, what's the point in implementing anyone at all?
Yes, ma'am. Yes. Workman is not, he is gainfully employed. That is my instruction.
The plea on the basis of you say the Labour Court has rejected the plea on the ground that there is no material to record, on record to suggest that the executive officer, Puri municipality, is a necessary party, and that the agreement filed also did not disclose the same. Full stop. This court has also perused the same agreement dated 23 July 2008 between the petitioner and Puri municipality. The only clause referred to by learned counsel for the petitioner is clause 1(J) regarding responsibilities of the parties, of the first party licensor, that is the Puri municipality. Full stop. The court is not persuaded.
That is of the petitioner.
That is first party licensor, sir.
First party is Puri municipality, perhaps. Your lordship may kindly see. It will be wrong. Otherwise, I have nothing to say, my lord.
Actually, responsible is the second party, licensing.
Yeah.
Okay. Yes. That is the petitioner. Full stop. Merely because the Puri municipality has the ultimate responsibility to reimburse the expenses incurred for statutory obligations, taxes, and fees will not mean that they become a necessary party to a labor dispute involving the present petitioner. The court is therefore not persuaded that any error has been committed by the Labour Court in rejecting the application filed by the petitioner. The petition is dismissed, the interim order is vacated.
Item number 25.
My lord. In this matter, I have received the additional affidavit. I have received, my lord, in this matter, my lord.
Your lordship, the PCCF has joined on virtual mode, Mr. Paul.
Yes.
My lords, we have filed the affidavit pursuant to the last order.
Where is that?
My lords, I filed it on.
Not on the.
Yes, my lords, I'm giving it. My lords, we filed it on Friday.
Have you served a copy on the petitioner?
Yes, my lords, the petitioner has been served.
Yes, my lord. I have received, my lord.
As on the last occasion, my lord had asked for two directions. My lords. One was with regard to the status of the 14 poaching cases that we had indicated in our previous affidavit. We have given the list of all the cases and where it is currently pending. My lords will find it at page 7.
So why is this case not started yet? If right from the first case of Attagad,
please, my lords.
Why is the case not progressed?
My lord, in maximum matter, charge sheet has been filed, my lord, just before 2-3 days, my lord.
Your Lordship, pardon, 2 minutes. Your Lordship, I have just. I have filed an intervention application. The reason behind is that even they are contradicting what they are saying. Because in affidavit I have filed, actually I am filing it today. They are saying that death has caused due to anthrax. But the report from ADRI, they are stating that.
Who's the intervener, sir?
Sir, Your Lordship, I have filed today. It's Purabi Patra.
Who's that?
She is an activist, Your Lordship.
All right. First, what is the IA number?
IA number 10706 of 2022.
All right.
One of the copy is not
10706, you just say
Your Lordship, I will
notice.
serve it today.
All right, just say notice. This is an application of intervention by one Ms. Purabi Patra.
Well, that copy is not served to me, my lord.
Your Lordship, I will serve it today.
Filed an affidavit. Copy of the affidavit be served on application as well as the affidavit be served on counsel for the petitioner as well as the counsel of the state. Now let's try and understand this chart.
Please, my lords.
My
lords.
My lord, in the first matter, my lord, that is initiated in 20th February.
Can I?
Mr. Mishra, we are asking, this is an affidavit filed by the state. We're asking the state to explain.
I'm sorry.
Except for the case at...
When we say status of trial, we don't mean started, not started. Whether it's charge sheet filed, what is the witness is examined, all that.
My lords, in most of the cases from, my lords will see most of the trial has not started.
Sir, again, I'm sorry to ask you this repeatedly. Before trial starts, there's a stage of filing of a charge sheet.
That's right.
Has charge sheet been filed?
Yes, my lords. The prosecution, the sanction has been taken, the charge sheet has been filed. The trial has to commence now.
Where do we get that when charge sheet was filed?
That, my lords, is not mentioned.
And then charges will be framed, right?
Yes, my lords.
Where is that? Simply saying not started is neither here nor there. Why is the old cases, these are cases at serial numbers 1, 2, 3 and 4.
That's right.
They're all 2018 cases,
yes,
right?
My lords. Only, my lords, the case at serial number 5, in that case, my lords, it is under trial. My lords, the trial is continuing.
What about the Sambalpur case? Where is that date of submission of sanction of prosecution report?
The Sambalpur case has not progressed, my lords. There has been no progress in the Sambalpur case. And thereafter, my lords.
And this 5/8/22 only now you filed. After 4 years, the charge sheet is filed, and in many cases, that's also serial number 3 still not filed.
Yes, my lords.
Why is that? In fact, a female elephant found dead with gunshot injuries.
Yes,
nobody arrested. Nobody suspected. How can it be? Look at serial number 3.
Yes, my lords. There has been no progress in that case.
No progress. I mean,
apart from serial, definitely there has been some lapses in terms of progressing with these cases. In fairness, but in most of the cases, will find that the suspected persons, at least most of them, have been arrested. That is
are they on? Now we'll have to ask you how many of them are on bail.
And from serial number 10, those cases are recent cases from May 2022. Those cases are under investigation by the Assistant Conservator of Forest. There are two aspects. Let me impress on
1 minute. Please. What is UD and what is OR? Case number, it says UD case converted to OR number. What is
Yes,
UD and
Millards.
OR?
OR is when Millards is transferred to the STF Millards. That is the original record case Millards. So Millards.
What does UD mean?
Unnatural death.
Millards, that's the unnatural death case.
Oh, I see.
So Millards, say suppose a carcass is.
An OR
is the original record case.
So these are not FIRs, is it?
No, Millards, these are not FIRs, Millards. They are registered.
On the complaint of the...
On the complaint of the persons, mostly forest officials, Millards, because under the Wildlife Protection Act, the forest officials are the concerned authorities to...
No, but if there are gunshot injuries...
Yes, Millards.
This is also involves Arms Act, wouldn't it?
Yes, Millards.
Then why is there no offense under the Arms Act? Because you don't know if it's a licensed weapon which has been used.
Please, Millards.
Why is no offense under the Arms Act? What's the name of the PCCF?
Millards, Mr. Shashi Paul.
Mr. Paul?
Yes, my lord.
So why do they not register the offences under the Arms Act when there's a bullet gunshot wounds?
Arms Act, my lord, I think we are not authorized to book under Arms Act, so that's why.
Not you to book. The police should do it. If it's an Arms Act offence, it's all cognizable.
Yes, my lord.
Why are they not doing it? If it's gunshot wounds, why are they not doing it? Why is there no progress in the trials, Mr. Paul?
No, my lord, a few of the cases what your honor pointed out, initially there was the first case that was initially just the dead body was recovered, and then there was no accused or no suspect. So then after investigation, then this was later on converted to a OR case, which I would like to submit before my lord that OR is offense report case in our department, and UD is undetected where we are not able to find out any offender. That case is categorized as UD case, and where there are offenders, then this is offense record case. So, my lord, the first case, initially there was no offender arrested or no suspect could be this thing, but after investigation, then later on this offenders, they could be traced out, and then the case was converted to offense record case. And the
all these persons must be out on bail now.
I have to check, my lord.
So why are you not keeping a monitor? This is the issue now. This is the real issue. If we are really serious about this issue, and this is growing in alarming proportions, correct? Yes, I think 29 July you had an incident, if I'm not mistaken.
Yes, my lord. Last about 2.5 months, we have nearly 5 incidents.
No. 29th July. I'm saying just now. In July, you had an incident. It's not recorded here, which is what I'm surprised. In your chart, it all stops at 7 July.
My lord, we have given details of the 14, what we said in the first affidavit. So
doesn't mean that you don't update your affidavit and tell us about all the cases. Between the last hearing and today, if there are some more cases, you should be adding that. The point I'm trying to make is this. If this is a systematic pattern of deaths of elephants, should you not be having a close monitoring of those cases?
Yes, my lord.
And you should not be appointing special prosecutors, See, unless you take these cases to the logical end, don't treat it as some other ordinary case. Once you find that the problem is growing in alarming proportions, we must have a more serious approach. How do you make the law work? If these offenders know cases will be lying in courts for years on end, nothing will happen. Meanwhile, they'll come out on bail. There is no deterrence.
Lord, we will initiate steps for
Who's
appointing
the
special.
STF? You tell us who's the STF. It comprises of whom? You are part of the STF?
No, no, my lord. STF is purely under crime branch of police, my lord. That's not. I'm not associated with that.
The STF part, Milords, what happened in 2015, there was a
my lord.
notification.
Notification had been annexed. I have annexed.
My lord, they are misleading the court, my lord. Kindly have a glance, my lord.
Number 21.
2 minutes, and after that, Milords, my friends can.
I will.
Milords, we have also given the notification where the STF is created.
My lord, kindly have a glance to the para 4, my lord. In that they have mentioned that there is no such.
Page 29 of my previous affidavit, my lord sees.
That is the extraordinary notification.
16th of October 2015, my lords.
The Wildlife Crime Cell functions under the administrative control of the Additional Director General of Police.
Director General of Police.
CID Crime Branch.
That's right, my lords.
So now we have to call the Additional Director General of Police.
My lords, the Director General of Police is a party, my lords, in this. And
then,
my lords, I have received instructions. So, my lords, the STF was functioning under the ADG. So the STF has other work. If my lord sees my affidavit, the present affidavit that I've filed, my lords may see page 4.
Yes.
It starts from page 3.
It has work as interstate drug trafficking, tender fixing, extortion.
That's right, my lords. Apart from this, my lords, the STF has been given this additional charge.
Whatever, that's okay. We are not. See,
that's
the
right.
problem is serious.
My lords, page 5, my
We've
lords.
had so many elephants dying in a short span of a few months.
That's right. So currently, my lords, the page 5, my lords. Currently, the STF has 3 DSPs, 8 inspectors, 2 SI, and 9 ASIs who investigate all the organized crimes, including wildlife cases in the state of Orissa, my lords.
So this is not our concern. If you want to adopt only one body for all the problems of the state, and then say, no, they've got all the problems of the state, so they cannot function. This is no answer to the court. Sorry.
May I, my lords, submit as a suggestion, my lords? My lords, if my lords gives me 4 weeks time, my lords.
What 4 weeks? You want how many more elephants to die? What is this going on?
My lord, kindly bear with me, my lord.
Mr. Ashish Mishra,
my lord,
please wait.
Let me, my lord, suggest.
We are responding to some submission of his. Don't please interrupt.
What the problem, my lords, as is seen from the ground is, my lords, because the STF, my lords, has other work. And so, my lords, this.
So, why did you not take it seriously?
Yes, my lords.
When one problem is alarmingly growing, you expect the same body, which has got so many other issues on its plate, to also deal with this.
Please, my lords. Please, my lords. Therefore, my lords, if I may submit, my lords, the PCCF and the my lords at the government level, my lords, we will come up with a dedicated task force, my lords, to deal with these cases. My lords may give me 4 weeks time, my lords.
No, there is no 4 weeks.
I'll come up with
number of elephants will just keep growing. The dying elephants will grow.
It's not like the STF and the forest officers are, my lords, not being vigilant. My lords, that is.
Please, I think it's so obvious what is happening. It's all in a certain range of places. In Attagad itself, you have 4 cases.
Yes, my lords.
No,
and
more than 4, I think.
In fact, my lords, for that a specific SIT has been created, my lords, only to deal with these Attagad cases, because it was seen that there was a syndicate running in the Attagad range. Therefore, a specific SIT has been created, and I have annexed that, my lords, in my previous affidavit, which is under. Which my lords will find it.
Mr. Paul, have there been cases in Ganjam as well?
Yes, my lord. Recently, just in the month of July, we had one case in Ganjam, my lord, in Gumtur North.
Where is that? There is no mention of that in your list.
It is there, my lord, number 14 on last page.
That Gumsur is Ganjam, is it?
The last.
Gumsur is Ganjam, my lord.
I see. But I think there are 2 incidents in Ganjam, or 1.
Second incident, my lord, was what has come out in the post-mortem report. That's a natural death, but one tusk was just one piece of a tusk was removed by some miscreant, and then that has also been recovered, and the person has also been arrested.
No, but you should mention that.
Okay, my lord,
Why have
sorry.
you not mentioned it?
Sorry, my lord. I just was under the impression the 14 cases what we have reported earlier.
14 plus whatever. See, let us tell you very frankly, if there are specific directions you need for this to become more effective, please tell us. Don't treat this as adversarial. See, the problem has to be tackled, right?
Yes, my lord.
If you think the cases are progressing too slowly, the investigation is too slow, or the prosecution of these cases is not effective, you have to get down to what the problem is.
Yes, my lord. If I am permitted to submit, then just as our government advocate was submitting, that if we can have a dedicated body which is dealing with these cases, then probably these cases can be fast forward. These cases can be better investigated, my lord.
So let's call the I'm going to call the Advocate General too, because we will need some different kinds of prosecutors for these kind of cases. We can't have the regular prosecutors. I don't know how many of these people are out on bail. You see it in the main case. We'll have it next week itself, Mr. Mishra. See, unless you have another, Mr. Ashish Mishra.
My lord.
Unless they have a dedicated task force just for these cases, nothing will progress.
My lord, kindly, I would like to make a point, my lord. Actually, exclusively, there is no wildlife crime cell, my lord. As they have mentioned in page number 4, my lord. Let me allow to read out, my lord. The STF, in addition to their original mandate related to investigating.
That is what we just read, Mr. Mishra. You heard me tell him that the same task force can't do all these. Okay.
No, my lord, the next sentence. No additional exclusive post have been created for the purpose of carrying out
Which is why let us call them and ask them to do all this.
My lord.
Your lordship, in the affidavit I have filed, they are having a special task force.
It is doing too many things, sir.
Your lordship, it is completely different. It has not been started yet. It is the notification is from 2008.
I've
the
received
PCC
this affidavit. Let me examine it. And...
Definitely, your lordship, they may have the right.
The affidavit filed today. You said the court has perused the affidavit filed today by Shri Shashi Paul, Principal Chief Conservator Forest (Wildlife) and Chief Wild Warden Odisha, who is also present online. Full stop. While better details of the 14 cases have been involving the illegal poaching of elephants in the last 5 years have been furnished, it is plain that the mere registration of these cases has not yielded the desired result of deterring the offenders from pursuing with their crimes. Full stop. The progress of the cases is also not satisfactory at all. Full stop. Except in one case out of the 14, trial has not started in any. Full stop. The affidavit explains that the Special Task Force (STF) Crime Branch is dealing with a whole host of problems apart from wildlife-related crimes, such as interstate drug trafficking, tender fixing, extortion and related offense, gang robbers, kidnappers, adapters for ransom, illicit supply of arms, ammunition, explosives, and so on and so forth. Gangs involved in trade of human organs and so on and so forth. Human organs and all matters related to terrorist activity. Paragraph. Clearly, the STF is overworked and cannot be expected to devote special attention to the task at hand, considering that the number of deaths of elephants in Odisha in the recent past has been alarming. The increase in the number of deaths of elephants in Orissa in the recent past has been alarming. Full stop. A concerted effort has to be made to activate the law enforcement machinery for strict enforcement of the Wildlife Protection Act and all other related laws, including the Arms Act, as in many of these instances, the elephants were found dead or grievously injured with bullet or pellet wounds. Full stop. It is surprising that in none of the cases the Arms Act has been invoked. Paragraph. The court considers it appropriate to call for an affidavit from the Director General of Police as to how the problem should be tackled. So in particular, how the investigations can be expedited, the accused arrested, the filing of the charge sheets expedited, and the progress of the trials, filing the charge sheets and the progress of the trials and the conduct of the trials be expedited. So the court also requests the Advocate General to participate in the next hearing to assist the court.
My lord, I pray, beside my lord, they have to clarify how many forest officials are being arrested and how they are involved in these 14 matters, my lord. Because they have not narrated, my lord, about the forest officials.
Seventeenth. Mr. Paul, are many of these are the persons arrested, including officers of your department?
Milord, in Atagad cases where some skeletons were found, we have arrested 6 of the departmental people, Milord, and 9 other persons.
You tell us what action you're taking even departmentally against them.
Departmentally, Milord, they already have been placed under suspension and there will be departmentally also charge sheeted, but they are also booked under the Wildlife Protection Act. And they will also...
Are they out on bail?
No, Milord. Only one person has got anticipatory bail, but all others are...
Regarding the liability of the officers involved, my lords, I had mentioned it in the previous affidavit at page 20, if I may read, that with regard to fixing responsibility on the official entrusted with the enforcement of Act, it is submitted that since 2017-18, departmental action has been taken against 3 DFOs, 9 range officers, 15 foresters, and 14
No, so what has happened to them? Action has been taken is one thing. What have you done?
They have not been arrested and have been...
Since when?
No,
those details are not there.
Yes.
Since when and what have you done? Have you carried those departmental inquiries to the logical conclusion? You say the court's attention has been drawn. You say list on and then add this paragraph in between. You say the court's attention has been drawn to the fact that in some of the cases, forest officials and employees of the forest department are themselves arraigned as accused, have been arrested, and departmental proceedings have been commenced. Full stop. A separate chart with an affidavit be filed by the PCCF on the next date, indicating the current status of the departmental inquiries against such persons, whether they are out on bail, and the progress of the departmental inquiries, and whether they've been taken to the logical conclusion.
High level list on.
List on. Seventeenth August.
Deeply oppressed.
All right. Over.